They have allowed the appeal and dismiss the registration.
Thank you.
For orders item number 2. Item number 2.
Yes, who is there?
I'm asking for the respondent what to. Sorry, what?
Mr. Someone from
Representation on behalf of the petitioner. IA number 14. Identification. Accordingly discussed.
Item number 3.
May dispose of this, my lord. Kindly recollect, my lord's direction in the writ appeal, bench of writ appeal with regard to appointment of junior teacher. The relevant is page 65, may kindly see. Page 55, my lord direction.
Yes.
Now, in fact, there are
65 of the order.
Yes, running page 65, that is the part of the judgment. That is the ordering portion. I will kindly turn to
Just a minute. Internal page 65 of the order.
yes. No, internal page 54.
54.
Yes.
Yes.
40. You say 65, page 65.
Running page.
Running page 65, internal page becomes 48 of that judgment.
54 of the judgment.
The internal page 54 of the judgment.
Yes,
Let us see.
that is. Lord, this order was threefold. I am concerned about the last one.
Yes.
Just I recollect my lord's.
Yes, yes, we
My lord was obliged. So, my lord, in the last paragraph, it will be. It will be opened.
712.
IA. I am referring to the IA man.
IA number 796.
7964 of 24.
Number
7964.
Yes, that is the,
Yes.
that is for construction.
Yes, yes.
I have got it.
Yes.
Kindly turn to the my lord's order clause
It is it.
first.
712. 712. 712. Sorry, 55. I'm so sorry. Yes, please.
Why? There are 20,000 of vacancies, 16,000 has been filled up.
No. you are
Now,
going
what is
to
the direction?
see.
It is, shall I
It
read
will be
my-
open.
Yes, yes.
Please read.
It will be open for the state appellants to refix this set of cutoff marks later from time to time in the event the post remain unfilled because of non-joining of candidate or other similar reasons, which shall be confined to the number of posts advertised thereafter. In view of the admitted facts that the score of the writ petitioners in the online CBT is less than the minimum marks scored by the candidates declared successful by the OSEPA, subject-wise categorized, we allow the state appellant to appoint such candidate taking into account their merit based on the score in CBT and district preference for the purpose of allocation of district. It goes without saying that the case of the writ petitioner shall be considered against the leftover vacancies in terms of the direction as above. So what happened, my lord? The 20,000 was the vacancy advertised. In fact, they have published a list of 18,000 only because this balance sheet 1,400 something. It could not be because these are the ST candidates, non-ability ST candidates. We are not concerned about it. We all are, you are an SCS. So now, after the completion of this process on 5/10/2024, only 16,000 candidates could have been appointed. So around 2,000 more are still lying vacant, to which my lord, as per my lord's direction, would have been filled up. But now they are not doing that, despite because the order they are taking advantage of my lord's order.
What is this application for?
For an appropriate order, my lord, at least they only 58% are before
Alright,
my lord. The
normally you
petitioners.
would not have
Even if
the-
they will descending order, they will fix the mark. We may get a
In
chance.
normal circumstance, we would not have entertained this application. But because of peculiar circumstance in which those directions were issued, we were compelled to issue such directions. Yes, please
Mine.
file your application.
Because I received the copy right.
All right,
You lodged
file
it,
your
I can-
affidavit. File your affidavit and see. That was peculiar fact.
Yes, your
In
lordship.
peculiar circumstance, we had to issue such direction. Otherwise, we would not have interfered with. Federal counsel appearing on behalf of the applicant. Sorry. The IU numbers transfer. This case on how much time? 2 weeks.
2 weeks time.
2 weeks. So as to enable LNDGA to seek instructions in respect of the amendments made in this application and file an affidavit. File an affidavit. File a reply.
Item number 4.
If you have the post vacant, you should fill them up. And we have indicated that you cannot go beyond the advertised post. And within that, if you have candidates.
Item 4.
Vigilance. Yes.
Agency. I have checked the judgments, my lordship, she wanted me to assist whether the review can be filed by the subsequent lawyer, but I'm just passing the judgment to the Supreme Court. I've already quoted in my affidavit, additional affidavit on maintainability.
But my submission, there is a limitation, my lord. My lord.
Lordship wanted me to assist my lordship whether the review can be maintainable, my lordship.
Review.
Review can be maintainable
Alright.
by a subsequent lawyer
Yes, yes,
Wait, my lord. The Tamil Nadu Electricity Board case, I have given the first judgment, my lord,
yes.
where it says, my lord, with consent of the previous lawyer, if you can be filed, my lord, in Supreme Court, because the occasion was arose, my lord, where review was dismissed, held by a subsequent lawyer, no objection was not taken, and registry pointed out that without no objections, it can be filed. Thereafter, a clarification, my lord, application was filed by another lawyer. In that situation, sir, Honorable Supreme Court said, no, without NOC, filed.
There is difference.
My lord.
All right. All right. For the citation.
The first judgment, my lord. This is also, my lord, sir, taken reference of the M. Purnachandra case, second judgment, my lord. It is a sad, may I read, my lord?
Which case you are referring?
First one, the Tamil Nadu,
Page number 1.
page number 1,
Yes.
Tamil Nadu case.
Yes, what is there? Was
This
it a
is
review
This is
application?
application for clarification.
Review
Not
was
review.
dismissed, then clarification.
Sir, we
Yes.
are on review,
I review.
not on application for clarification. We are on review, principle of review.
Basing of this judgment, not special any other judgment. The next judgment is also same manner. Sir. Review one. Next judgment, sir, page 3.
Reference value.
Page 3. M. Purnachandra case matters. These are the two judgments available in so far as the whether review can be filed by a subsequent lawyer or not.
Sir, our High Court
Yes,
in division bench,
yes,
following two honorable Supreme Court judgments
yes,
in division bench as well as in single bench, 2 or 3 cases,
yes.
deprecated such practice.
These two judgments
What
only.
would you-
These two judgments where it says man, with consent it can be filed, my lord.
Mr. Counsel, we shall follow the judgment.
My
Don't worry.
My lord, my lord,
The judgment which you are relying
my lord.
on, we shall follow, and
My
that
lord.
will be very difficult for you. If we follow the decision,
Yes.
that will be difficult for you.
Now, my case is much altogether different in this scenario. There is no vocabulary filed in my main writ petition, my lord. I have obtained consent. The public interest litigation was filed. My case is altogether different, my lord. This two cases also relied by this honorable court by a single bench, my lord Justice Paningrai, and they categorically stated that without consent can be filed. This Purnachandra is followed, and
What about a Red Deer case? What about a Red Deer?
they are followed this.
Yes, sir.
No objection.
Yes, sir.
No objection. Yes.
My lord, this has taken note of that Purnachandra case of this second judgment, my lord, so I have quoted, and where it has the registry should not have accepted the Vakaldama without NOC. NOC is the requirement what my lord pointed out on all these three judgments, my lord, Supreme Court as well as this our judgment. Also.
So counsel, NOC is required.
Yes,
When another lawyer appears in the same case.
yes,
It's a different case review.
yes, review, my lord. In case of review, my lords, in case of review,
In
my
case
lord,
of review, you are not required to take no objection. Do you understand? It's a different case altogether. The Supreme Court has deprecated the practice of engaging different lawyer
yes,
for filing review application.
yes,
So this is different. In this case, in the judgment on which you are relying, in that case, in the same matter, an application was filed. The question was whether it could be entertained without no objection. In that circumstance, the order has been passed.
yes. And this judgment, both the judgments have been followed by our High Court in this single bench judge order, my lords,
Sir, you are not satisfied.
where it has been taken the note of the Advocates Welfare Funds Act 2001. What is the requirement of NOC? Now, I am not coming to the NOC now, my lords. My case is, my lords, very simple. Is the public interest litigation is filed, my lords. Here, by opposite party number 1 and 2, making party opposite party number 6, my lords. There, my lords, what has happened, notice was issued on the date, let's say, can you see the first date of
The
the,
council, you can challenge that order.
yes,
You can challenge that order before appropriate forum. You
Yes.
cannot seek review of that order. And that too by changing the lawyer.
I will satisfy your lordships, all the review grounds has been,
We are not satisfied on the first ground that you could not have filed the review application. And we are going to impose cost if it's required on you.
Here, my lords, what has happened was, here is the DT is the review petitioner before your lordships. DT has always considered by my lord as a minor, my lord. And we are the protector of the DT, my lords. What we have done, my lords, in this case, my lords, we had approached Supreme Court for SLP, my lords. The lawyer from Supreme Court opined that, my lords, it is a fit case for review. Please go and file the review because you have not filed any counter, not filed any document bringing to the notice of the Honorable Court, my lords. And there are misrepresentation of fact. Fraud has been committed by the petitioners as well as in collusion with the opposite party. Number 6, my lord. This is the case, whole case, my lord. I will bring one by one why this is altogether
So we
different.
should follow the opinion of the council from Supreme Court. This is what you want.
This is Jagannath Temple, my lords. It's a minor in law as per my lord's judgments, my lords. Only
All right, we will pass order.
no, I'll point out few things, my lord. Very important things, my lord.
Sorry, we are not satisfied. You cannot appear.
In scenario, my lord, what has happened, my lord?
No scenario.
PIL has
No
been filed,
scenario.
my lord.
Let the same person file.
I have not filed any document before the writ court, my lord. I have not filed any document, my lord.
You are not satisfied. You could not have filed review application. We could have entertained review application filed by the lawyer who was there.
When the lawyer is refusing, my lord, what to do, my lord? So I am a minor. When the lawyer is refusing by writing, my lord, I have given those document, lordship, and NOC has been given, but no proposal was filed in the writ court, my lord. No lawyers was, no proposal was filed. That is surprising, my lord. No proposal was filed by any lawyer in that writ court, writ petitions on behalf of this temple administration, my lord. That's why the right comes to me, my lord.
Just a minute.
My lord, I'll have a look.
Participated and in the order sought to be reviewed paragraph 5, they have made the argument. That is also noted.
No
And
proposal was filed.
order dated 8/1
On the day of
31st.
passing of the order, that my first appearance, instructive counsel appeared, asked for counter to be filed, my lord.
All right.
No time was granted.
All right. All
But
right.
no Bhakalta was filed,
Just a minute.
my lord.
Some lawyer had appeared.
Some lawyer has appeared at the instance of the
Will you
court, my
answer
lord.
yes or no?
My lord, yes.
Some lawyer has appeared. Please wait.
Yes,
Some lawyer had appeared
yes, my lord.
on your behalf,
Yes,
but you had not authorized him. Are we clear?
yes,
Because he did not have Vakalatnama.
yes,
The Vakalatnama he had not filed.
yes,
So he was not authorized.
yes.
Is this your submission?
No. In addition to that, my lord, the court, at the instance of the court, the counsel has appeared, my lord. Let me kindly see the order number 2, my lord.
Mr.
Notice was issued.
Mr. Counsel, we also have a right to be heard,
Yes.
at times.
Yes,
So unless you don't hear us,
yes,
you will not come out with correct answers. So our first question is that some lawyer had appeared on your behalf. 1. 2, the lawyer, according to you, was not authorized.
no,
Two-
not filed Bhakaltanama.
Huh?
Not filed Bhakaltanama.
Not filed. What is Vakalatnama?
But he was instructed to take time for the counter, my lord. Instruction was given, not filed Bhakaltanama.
Mr. Counsel, don't you understand the basic meaning of
Yes,
Vakalatnama?
Bhakaltanama.
What is Vakalatnama?
Authority,
Tell
my
us.
lords.
Vakalatnama is authority.
Yes.
That authority was not there with him.
There.
therefore he was not authorized. Is this your case?
No, not that is the case, my lord. So my
Just a minute on this point,
Yes.
that because he had not filed Wakalatnama, therefore there was no lawyer on your behalf in that case. This is what you want to submit.
that is one part of my submission.
That is one part. Let us
Yes.
complete the first part.
Yes, yes. That first
So-
part, my lord.
First part.
Yes.
So, did he commit misconduct? Your lawyer, the person who was appearing for the petitioner,
Yes.
did he commit any
No
misconduct?
misconduct, my lord.
He has not committed any misconduct.
No.
Then you are committing misconduct.
No. But how? Because I have got the NOC minus from the lawyer, my lord. I have got the NOC from the lawyer,
We-
and it's a public interest litigations, my lord.
We will
The
see what order,
petitioner wants
we will see what order can.
personal benefit is between the petitioner and opinion number 6.
We will see. Order them. We have followed Bombay High Court. Because we cannot have a different view with that. See, that was done earlier also by this court, following Madras High Court. That we have dismissed.
Item number 2, WPC 10776 of 2024.
Very prompting mention. I agree.
Give us.
If I want to make a mention.
Mobilize man.
Tender matter, my lord, tender with regard to wild animal medical products were illegally committed by the director of London Canal, my lord. Kindly taken up next to tomorrow, my lord. Very humbly I am submitting. Kindly taken up tomorrow.
Have you written all the reasons?
Reasons
Reasons why the matter is urgent, have you written?
that
Right.
illegally has been committed by the
Illegality is of various types. Why is it urgent? You must mention so that it can be perused.
tomorrow.
Urgency is that the matter will become infructuous because of the flesh tender we have.
I may be pardon the application before your loss was passed to please to pass the order and matter was displayed before your
Give it.
content of teacher. Already taken instruction to comply with the order by your loss.
Parang to mention obligation number 2024. The status for the municipality has received to work the smart city. Kindly list it.
Pardon me, mention. Because it's a CRLMC matter, but if the roster bench has recused itself from hearing the matter, it may be taken for any other bench. The roster bench has recused itself from hearing the matter.
Tender matter, my lord. One matter is listed today to tender. Next matter is left, my lord, name taken up tomorrow.
Which is that matter?
So 23, one tender call notice, two rate application.
Let the matter be taken up. That matter be taken.
23, one matter is.
After that matter is taken up.
The procedure will be taken up with that.
Item number 3 for delivery of orders.
Yes, please come. Yeah, in WPC 25371, who is appearing?
We are for the opposite parties, man.
You are appearing. What was your case?
CBC can detail.
That's SCBC. You have the certificate.
Man, I have it.
Where is that?
Mr. Patnaik, please. Everybody doesn't have SCBC certificate, so please be specific.
Do you have your brief with you? Don't have. You need that. Otherwise,
Look, out of the 5 petitions,
we'll-
4 is having CBC.
please come at 2 p.m. At 2 p.m. we'll deliver the judgment.
All right, you get your file and come.
So your matter relates to admission to your
Nursing
admission,
issues.
and your relates to
Dealership selection, man.
selection.
My lord,
Dealership
we are for the writ appeal, my lord. My friend is writ appeal. 2484 of 2024, BPCL, my lord.
All right, at 2 p.m. Please come with your brief.
May I pray, my lord?
2 p.m.
Tomorrow.
No, at 2 p.m.
Why not at 2 p.m.?
So this is
No, but what is the, so this is HPCL, that can wait.
BPCL, I am for the BPCL.
Your matter can wait.
BPCL, that can
So
wait.
that we can keep it to tomorrow,
Monday.
Monday. All right.
And this will dictate at 2 p.m.
But
All right.
writ appeal ported for Monday. Okay.
Matters under the heading for orders. Item number 25.
Lord, this case was delay of 234 days, but this was already issued on.
The last order क्या happened है? You're saying the matter is pending before the Supreme Court?
My lord.
In which matter?
SLP,
Not this. Item 25.
SL
Dated order is not there on record. Sorry.
SLBC 2146 2024, madam.
Name of the party.
Shekhar Jaina.
Yes. That, what is the present position?
President on 1911 order the reserve.
Order reserve and executive date of question. All right. Mr. P.K. Mahapatra, Learned Counsel. Acha, delay, then let us respond on the delay and we will abide by the decision of the apex court. All right. Mr. P.K. Mahapatra, Learned Counsel, appearing on behalf of the respondent, submits that, you want order to deliver? Yes. Submits that matter is covered by the decision of this court in the case of WA number 1134 of 2023. But the same has been challenged by the state of Odisha in special in SLP C number 2146 of 2024 and batch, where the matters have been heard on 19/11/2024 and judgment has been reserved. He files the order dated 19/11/2024 of the Supreme Court, along with the memo, as well as the decision of this court in WA number 1134 of 2023. Full stop. Lists the case on 10/12/2024.
Item 26.
Along with connected cases. So, how gonna get to the corridor?
Item 26. Matter related to block grant teachers claiming pensionary benefits.
This matter was supposed to be argued by AG. And moreover, it requires a convenience compilation of all the statutory rules and which is to be shared with everyone when I'm preparing that.
In fact, so far as we are concerned, it's a batch of cases, those cases, and one common judgment. In those cases, we are appearing for the respondents. And in this case also, we have filed an application for intervention. Sure. So those cases require also to be heard, respect as convenient to
There are how many applications for intervention?
About
1, 2, 3,
600.
4, 5.
600.
600.
600, more than 600 writ appeals are there.
Yes.
And out of that, this particular matter was kept for today to be heard so that whatever will be the result, that will be following
So
other
our
cases.
problem is, there are different types of cases. Common judgment judges, schools,
college,
junior college like this. So we,
All right, 600 intervention applications are
no,
there.
no.
Independent writ appeals.
Read appeals are
State is fine.
So were 600 disposed of by
By
one
common
state?
No, different.
Common
By
judgment.
common judgment.
Judgments.
All right. How many issues are involved?
But issues, that can be numerous issues. But one of the issue is these institutions, those who have already declared notified to be an aided educational institution, whether they can be discriminated for the purpose of granting pension in terms of 1981 rule, that is a statutory rule.
As far as the government,
That's right. Government has given to the dad.
After 2017, there is no problem.
No problem.
No, there will be two according to subject to.
Just a minute, the judgment is one.
Judgment is
Prior to that, another judgment was there. That was
No, the judgment
Got
which
to
is under
Supreme Court.
challenge,
yes.
the judgment which we have to consider is only one.
Yeah.
this
Yes,
judgment today's hearing, that is one that connected with about 500 cases.
Mr. Rautraj, so the issues which you are saying are different, all have been considered in this one judgment.
Yes.
Right, we can consider any date.
It also involves two
I have
departments.
a submission there. May I submit? There are two categories. I don't know what my Lord Seniors will argue. But there are two categories of persons before my Lord in this one judgment, whether there are aided institutions receiving direct payment from the government. And some of the employees of that particular type of institutions later on get block grant. Whether those block grant employees of that old institution will get pension. One of such cases was disposed of by my Lord in that Sarat Parida's judgment, first judgment in 2015. That went up to Supreme Court and the government has implemented that order. So it has been dismissed not on merit but on
The
a
ground of delay.
delay. But that has been implemented by the state in respect of that case. Another set of employees are there. Some institution, those who have got into the granted is set of block grant in a later date. Those are not a direct payment institution. Because the rule, my Lord, will see 1981 rule.
We will have the advantage of hearing you also. Once we take up the matter for final,
That is one.
we can, any.
Yes.
That is why another writ of another
I was also
division
told
bench
whether-
has also segregated these cases.
Single counsel.
Yes, sorry. Yes. That is.
I was also told may not be correct because certain policies now, so far the pension is concerned, they are contemplating some action. In fact, they had done instead of giving them regular pension, they had fixed it at 10 lakhs, 15 lakhs like this.
So that is-
that was challenge that has been passed and that has been subsequently also the issue that they withdrawn. So all this.
The government, we may not be correct, but the corridors whisper is that the government is
We hope so.
contemplating whether to implement this order.
That is for my friend to take. I don't know. We can't.
We can't make any official
I think that
statement.
instruction I don't have. I only pray, but so far as the.
Just a colleague
merits of the
has to
case
here.
and Advocate General has to argue. So Lordship may keep it to 2 weeks after. I come prepared
Yes,
with the
yes.
convenience compilations and everything.
Why not on 19 or 20 digit person?
Those base of cases were not totally fast. Malady. These base of cases are similar matter. Was a
January.
bench before this put in a special list.
Road.
That is
No, why-
This is one of them.
one of them. But
This
those
is
cases
one
are
of them. Those cases, this one was segregation.
I can assure one thing. We can assure you one thing. That since it involves some question of law and it may have wider ramification, so therefore, even if learned counsel who are not appearing in these matters, they shall be at liberty to address it.
Yes, exactly.
Yes, because
That-
that's a conflict of argument also.
Because somebody told that, your Asif said that the first case will be hard.
No,
That's right. That is exactly, absolutely.
See,
That is our entire thing.
Otherwise, there was no necessity of.
no,
Right, right. Absolutely, you are
such
correct.
matters, in such
That is the only
matters,
thing.
we-
There was a colleague
surely-
there, 3 chapters.
Surely, and that will,
That will suffice.
That will not.
and therefore, my question was that if 600 intervention applications are there,
No,
then how many lawyers are there?
No,
That
no,
was
no.
on a lighter note, but
Section.
I think 5-6 laws can address your lordship, that will also cover whole thing.
even if someone wants to,
Yes, can your lordship, yes.
please,
Yes, sir, yes. Yes. Father,
I don't believe in that shortcut.
we know, at least we have that experience now.
This is just the short, the list.
Yes, we can, yes.
Short, otherwise 5-6
Yes,
pages.
yes. That will be. Well, the web's council is not quite.
Higher numbers.
તમે જ્યાં કહો છો સી વિષય બોલતો.
So we will take up all interlocutory applications.
Yes, yes,
application
yes,
application
yes,
at the
yes.
time of it. Then give us a date,
Any date after 2 weeks.
2 weeks. kar do,
ના,
date.
can it come?
17, 18 की इनके होंगे.
17.
17.
17.
20, December 17.
2 p.m. 2 p.m.
Okay.
will take.
Yes,
Yes,
yes.
come with your
Oh, yes.
points and notes.
Yes.
Item now 27.
11 days delay in filing the application.
Yes.
Same for the other side.
Notice has to go. Why don't you serve a copy on Mr. Pal in case he accepts the copy, otherwise please do notice. What have you stated, what the reasons for delay?
Because of the rain, he is staying at Karanjia, 250 kilometers away. And due to rain, he cannot, could not come in the time.
Who appears for the other side?
So no trouble, but delay. Yeah. Pradeep Kumar Mahapatra.
Yes.
Pradeep Kumar Mahapatra. The order shows prior Mr. Pal. Are you sure? Pradeep Kumar Mahapatra
Pradeep, page 15. madam.
for the bank.
Yes, for the bank. Page 15.
I. This application has been filed for condoning the delay. Have you mentioned the period of delay in that
Yes,
case?
yes, yes.
For condoning the delay of
11 days.
11 days in filing the writ of appeal, full stop. The ramp reporter has indicated the delay to be 27 days, full stop. Sorry? Considering the explanation given in the in the application for the delay in filing the writ appeal, and considering that the delay is 27 days, considering the period of delay, we are satisfied that it is a fit case for condoning the delay in filing the writ appeal in the interest of justice. Full stop. The delay is accordingly condoned. The delay in filing the writ appeal is condoned. The I is allowed and disposed of. List this appeal for fresh admission on 3/12/2024.
Item 28.
This same PLM lot for restoration in respect of the WPC, my lord, that is 23,219 of 2013.
but my lord, list so far my lord reflects that 23,019 of 2023 has come, my lord.
I
That
think
matter has not
correct
been
one has-
disposed.
Anyway, tell us.
My lord.
Why have you filed the IA?
I have filed the restoration of the writ application along with my lord. This writ application dismissal at on 7/4/2022, my lord.
Oh, yes. Then you had filed an IA for recall of the order, which was disposed of, granting you liberty to file a proper application because that was not maintainable. And it took you how many months to file this properly constituted application?
I filed my lord. I'm got a transfer base, my lord. I got a appearance on 22nd 12/2023, my lord. I filed on Hokata the transfer bill, my lord.
All right. But IA had been filed by you.
My lord, my
So I am asking after disposal of the IA,
my lord. That I am disposed of 5/4/2024.
and this
I filed, my lord,
5/4/2024, and this has been filed when?
or filed 18/4/24.
But the certified copy is also not there.
I filed exemption.
Full stop. Heard Mr. Ashok Das, learned counsel for the appellant, for the petitioner. This, first the IA 141 of 2024. Full stop. This IA is disposed of as redundant, not necessary. Mr. Tapare CMPL. Dispensing with filing of certified copy. Have you filed?
My lord,
When?
my lord, that is my lord. IA number 189 of
When did you file the copy? I could not find it in the digital records. Have you filed it?
30/4/2024.
34/2004 you filed it.
30/4.
अच्छी record में देख लो, वो तो file नहीं digital record में scan है नहीं. IA 189 of 2024 for dispensing with filing of certified copy of the order.
That is the IA filed for dispensing with the certificate. That
This IA has been filed for dispensing with filing of certified copy of the order dated
7/4/2022.
7/4/2022.
7/4/2022. 22.
for the order dated 7/4/2022, passed in WPC number 23219 of 2013.
That is correct.
13. Full stop. Considering the fact that the matter was listed, last it was listed when?
That is Mr. Miller 5/4/2024.
Before 7/4/2022, the matter was listed 9 years back, I think.
My lord, I transfer.
Anyway, forget it. And considering the reasons cited in the IA, cited in the IA, and the fact that the petitioner, the learned counsel for the petitioner was not heard when the matter was disposed of, we recall the order dated 7/4/2022, passed in WPC number 23219 of 2013, and restore the writ application to file, list the case before the assigned bench. Mr. PK Padhinkar on all right. Mr. Padi has not been heard, so we are allowing this CMPL. Do you have any objection?
Only request I have, because this rate is a very old one. They let my friend a survey copy. Because we don't have all, except the IA and CMP or nothing left.
Learned DSG submits that a copy of the writ application may be served on him in order to enable him to obtain instructions, and it is the old case of the year 2013.
Yes,
the copy of the writ application shall be served on him by Friday, by 29/11/2024. Draft yes.
Oblige, ma'am.
The double PC has come, that will be separated. Obliged.
देखिए order देखिए we'll give
29.
In fact, I missed to. Will come after 1 week.
My lord, wanted to know regarding the fact that what is the status of the criminal matters they are posted on Thursday, my lord.
Yes, yes. What is the status?
It's on 12, on Thursday it's coming up, my lord. The notice has been issued and the state is to respond, my lord.
Where?
Before Justice S.S. Mishra, my lord.
No, no. We will close that. We will close this.
And the other matter also, my lord, the commission has proceeded. They will probably complete the proceeding by 27th of January, my lord. Probably. That also has proceeded. My lord. Rest.
Orders matter over. Item number 9. It will be taken up fast.
Number 4.
You are in which matter?
I am in 4. I think it's serial.
So it is notified item number 9 to be taken up fast.
Must have been notified.
It's
Number 4.
Yes.
The special messenger is allowed to file the counter.
I don't think there is any time for filing
Sorry.
counter. That is why copy had been served on Mr. Palit. Thereafter, since he did not appear, we were compelled to issue notice. Tomorrow. When is the last date?
Last date of no. Last date of joining is 5th December, my lord. And the state council is 25th to 29th December. Last occasion I have handed over the.
But Mr. Yetti,
Yes, ma'am. This is legal.
what is the document showing that you are a NRI candidate? Because your documents which you have given shows that you are a general candidate.
So not answer.
Yes, what are you saying?
I think petition number 1 has already alerted 4 times. My lord, already conducting 3 round counseling and one spot play counseling. The petition number 1 has alerted in all the 3 round in the MBBS under the NRA quota category in the OP number 8 college, but he has not appeared in the document verification time. And in
But
the state
I think better if you give it along with an affidavit. If you keep it to tomorrow, can you file the affidavit?
yes, my lord.
Tomorrow, because there's some
Everything is
urgency.
ready, my lord. I will file content, my lord. Everything is our
That is
outer
what
is
I'm
ready, my lord.
saying.
We will
That
file
is what I'm
content.
saying. If we keep it to tomorrow,
My lord.
please serve copy of the affidavit and also produce it before this court so that we can take it up tomorrow.
My lord.
Petitioner 2 also you get instructions?
It is not about who has alerted.
Anyway, all those instructions you give.
My lord.
You don't have to do anything, Mr. Mahdi.
Because you have already intimated JE.
Okay.
Take care of. And I will also putting my question.
No, not required because they are admitting that you are there under the NRI quota.
Yes.
I did not find any document, that's why I was asking.
They have alerted.
You are appearing for?
97 notice was sent to me, but it are not.
Yes, so you are not at home. 6 and 7 are not at home, so you are appearing for OP 6 and 7.
May I pardon my lord?
5, 6, 7.
All
May I
right.
pardon
5
my
to
lord?
7.
Yes,
My lord, petitioner number 4 on stray counseling. He has not.
4. There are only 2
Sorry,
petitioners, I think.
Sorry, my lord. Petition number 1
Yes.
is not able to produce the document
So-
on this stray document.
So you are not going to file counter, we'll dispose it off today.
Tomorrow, my lord.
Oh, exactly. Yes. You are Mr. Mishra.
My lord.
Mr. Mishra, Amitabh Mishra. Mr. Amitabh Mishra, learned counsel submits that Mr. Subir Palit, senior counsel and associates have instructions to appear on behalf of opposite party number 8. 8?
4.
Opposite party, sorry. Who's OP8? The college.
College.
Have instructions to appear on behalf of opposite party number 4 and shall file counter course of the day or tomorrow.
In course of the day.
They shall file wakalatnama and as well as counter affidavit of the opposite party number 4 in course of the day. Let that be done, serving copy on learned counsel for the petitioner. List the case tomorrow to be taken up. To be taken up as the first case. Full stop. Mr. Mr. Deepak Kumar Parida, learned counsel submits. Have you filed wakalatnama?
Yes, I will find it.
File it. submits that he has instructions to appear on behalf of opposite parties 5 to 7 and shall file wakalatnama
Yes.
in course of the day. Do it fast, otherwise it won't come on record.
Yes.
ঠিক আছে, সেটা আমি জোড় দেবে। I'll list the case first, that will be the last line.
Okay.
Yes.
Item number 4.
Content. Right, because on the date I did some law and prepare myself.
This every day this matter comes, somebody asks for a pass power and then it is adjourned.
I will set up in other
All right.
associate, but I could not prepare myself. That is my problem. Some judgment is what I did it.
And discussed by Mr. Das and counsel appearing on behalf of the respondent. Only one respondent, specific matter on. Yes. 1 week.
Third.
Two respondents are there. State is a performer party.
So respondent number 1.
One line.
Fantastic.
Respond number 1. Yes.
3rd December.
That is something here. Those
10.
10. Item number 5.
Where is it? Issuance of LY, favor of opposite party number 4 is being asserted in the present writ. The challenge is essentially on the ground that the bid which was submitted
So
was.
you are challenging that.
Sorry, Mali?
You are challenging
The issuance of LOI, yes. But this,
so therefore, that was the policy decision which we interfered in case of Rose Mata. In every contract, someone is challenging either the.
well, here is a case where your lordships will find that the bid which was submitted was a wholly incompetent bid.
All right.
It ought to have been rejected in limine, but the way the opposite party number 4 has been accommodated by the
All right, let us see.
is something very glaring.
Let us.
Now, if your lordship takes page 123 of the brief, that provides that the earnest money is to be provided by way of a bank guarantee. One of the modes of furnishing the earnest money was by way of a bank guarantee, and the format is provided at page 213. 123.
Yes, 123.
Now, your lordship finds about
You are referring to 223.
123.
123.
123, bid security applicable in case of bank guarantee. Now, if your lordship takes the first paragraph, 7th line,
Yes.
that provides for insertion of the RFP number. 7th line into the first paragraph, request for proposal number, insert RFP number.
123.
Page 123, first paragraph, 7th line.
Digital.
Page. Yes, where?
7th line into the first paragraph,
Yes.
it says, contract basis with reference to request for proposal number, within bracket, insert RFP number. Dated so and so, so and so. Now, the RFP number in this particular case, in this particular tender, your lordships will get at page 215. 215, that's what I'm correct number.
Page 36.
Page 36,
Fourth
Maharaj.
line.
Page 36 of what?
Page 36 of the brief, under it fit, Annexure 2 balance. Page 36 at the top, your lordships will get the bid identification number is so and so 46 of 23-24. Has your lordship got that? 46. Now kindly take the bid.
46.
Yes.
No, page 36.
No, page 36
Identification number?
is the page 36.
Page 36, yes.
36 provides what is the bid identification number.
Yes.
Top bid identification number 46 of 23-24.
Yes.
Now kindly see the guarantee which the opposite party number 4 furnished. Page 215.
Page?
215. Now your lordship sees the bank guarantee with bid security which the opposite party number 4 has furnished. That is in respect of bid number 65 of 22-23. It's a different bid altogether.
Where is that? Where is that?
At page 215,
No, where is it?
end of last line of first paragraph.
Yes, 65.
The bank guarantee is at page 201. The bank guarantee which the opposite party number 4 has furnished. That's at page 201.
So you are referring to 201 or 215?
201. 201.
Yes.
This, your lordship takes the last paragraph on 201. Fourth line into that paragraph, the bid identification number is different. It's of 6 of 2022-23. It does not relate to the bid in question.
Yes.
So the bid, the security which was bid security which was submitted by opposite party number 4 was defective.
Let them file affidavit. It is so present then.
No, they have filed an affidavit in response they do. Now, what if the state government takes the stand that since they are an MSME unit, they are exempted from making the earnest money deposit. Now, I have two limbs of submissions here, madam. Firstly, the exemption was not sought for when the bid was submitted. If MSME certificate was injected into the transactions much after the bids were opened and a complaint was raised.
That cannot be decided here. You can file a suit.
No, the second thing is that MSME does not apply to works contract. This is a works contract.
All right.
Why not?
Works contract is excluded from the purview of MSME. There are many judgments on that point. I can satisfy
But you are not disputing that he is, OP4 is a MSME unit. That's not disputed.
I am conceding for the fact because only one of the constituents have.
MSME we will have to examine the statutory provisions. Why should we refer to the judgments? Let us see. How do you say that works contract is excluded?
The MSME Act was.
Beneficial.
And on what basis? Where is the judgment that that it be excluded?
I haven't
Then you-
heard the judgments today. There are many judgments on this point.
There is no interim order.
Grant.
There is no interim order. All right. When do you want?
But tomorrow.
Tomorrow, no, it is not. Every day we cannot take up your matter.
Day after tomorrow.
Sorry.
My lord, this is one point. There are five aspects which I will bring to your lordship.
We have so many things to do. It
I
is
know
not
your
that
lordship
today we will take up
I know
your
your
case for 10
lordship's board
minutes,
is very hard.
tomorrow 10 minutes, and we will
No,
take up.
my lords, let me go to the second point.
After hearing you, can we close it today?
Yes, my lord, I can give the judgments. I can give the judgments on the table.
No, it's not that today you will argue, tomorrow you will.
I will submit the judgments, sir. I have the judgments.
Bring it while you argue he can bring it. So don't refer to a judgment which you have not placed.
Huh?
And Tagore Kagadala, give us
The 4 or 5 judgments I am giving the references right now. Right now I am.
This matter on.
That's the second point.
Let me hear you later, Mr. Week. So as to enable and counsel for the petitioner to place the Supreme Court's decision in support of the submissions which he has advanced. 1 week.
And the other points which
You may or make submission on the next.
With all respect to my understanding, I deposited enter because of pending they have not issued a law.
Make
We'll
your
hear on that day. We'll hear finally.
Phase 2-1 is the 2020. Because only one humble troubling your also 1 minute. Because
What will happen? 1 minute if you trouble, how can we help you? We'll help.
The petitioner who is a L3, he made a statement in the affidavit on the preliminary objection that I am not able to deposit FPS amount, financial. So,
Why don't you show us on the next date?
yes, I'll show.
Item 6.
Yes.
In compliance with your lordship's order, the counter affidavit has been filed and a cost of rupees 1,000 is also deposited with the bar.
Yeah.
But
Yesterday evening, I have received the copy of the affidavit filed by my landlord.
Trust and counsel on behalf of petitioner states that he has received a copy of the counter affidavit today itself.
Yesterday evening.
Last evening.
And we have deposited a cost bill.
Requires to consider 246 adjournment for that purpose. So let's this matter on 2 weeks. 2 weeks. We when AGA has
When?
informed this court.
When?
2 weeks.
When did you deposit?
Cost of
Tomorrow. Yesterday.
as directed by this court has been deposited yesterday in the appropriate account.
Item 7.
Like yesterday, the case was, we have already recommended to government for NOC for D pharma. That is what yesterday 2 cases were there.
Only recommended and not issued NOC mine.
After government gives approval, we will give the name.
But instead of D pharma course mile, petition running since 2019 mile. Instead of D pharma course renewal mile. That is recommended, but till yet not issued mile. The government may
So you applied for D pharma
mile.
and they have given you B pharma.
B pharma mile.
That's why I am giving now. We have
The B pharma was earlier approved.
No. Previously it was there.
So B pharma they don't have.
They are.
No, I have no B pharma.
No, that you don't know. Don't say without it.
B pharma he doesn't.
All right, file your affidavit. Bills. File your affidavit.
He has already given.
No, now they.
I'm not
My
only recommended. They have recommended to government.
Recommend to the
Not
government.
issue mile it will longer. If dispose of it will longer. Till more time and it will be becoming. Next week mile.
Yes, Mr. Montil and counsel representing the DMET has submitted that DMET has recommended the petitioner's case for grant of NOC.
Renewal of NOC.
For renewal of NOC for
D pharma.
D pharma course for the academic session 2024-25. There are two matters.
Otherwise, yesterday disposal of matter.
Let's this matter on 1 week. In the meanwhile, when the AGA shall be required to seek instructions as to whether pursuant to a recommendation made by the DMAC and DMET, the necessary NOC has been issued.
Serial number of order is
Serial number of the order.
Item number 8.
Item number 8.
Yes.
It's a green card matter.
Who knows this?
He's not been considered for green card because there is difference between the card number and the application name.
that he was mentioning that Kumar and something.
Yes, madam. The second thing is that they are over 335, 36, they are in green card on government colleges, government institutions.
What is that green card? What is green card?
This is average number.
All right.
My lord, his serial number is 46. Up to 37 serial, we are given admission. And she has already taken admission in a private institution. During pandemic.
But that because she couldn't take a risk to pay more fees.
Yes, sir. My lord, also there is a condition. If at any time he was permitted.
Well, if there is a after this filing this case mark, he took admission because unless you spoil the time. That is what. And there is also a condition if you get issue from the you get issue from the same college.
His
Transfer
position,
certificate.
her position would be 43.
46.
46. You have given up till 37.
37, up to 37, we are given all seats of freedom.
Maybe he doesn't have anything.
If he's a
No, in case there is any vacancy in that.
Yes,
category-
model, that is good. They consider and if there is a vacancy for the
In the presented application has sought for a direction to this is something.
Item 8. NRA is different. This is item 8.
Yes. Reconsider the petitioner's candidature for admission into a nursing course in a government institution
government.
based on government institution by giving due benefit of a reservation under green card holder category. The counsel appearing on behalf of the DMET has submitted that in the green card holder category, 36 or 37, 36 the students have been admitted.
37.
37 students have been admitted and
23 seats are there, have given in legal side.
no, that is
23 seats are there, up to serial number 37. They have taken.
students up to serial number 37 in the
Three seats.
you understand? Submitted that green card holder category candidates up to serial number 37 based on their respective merit have been given admission. So the petitioner's rank is serial 43. 46. So the petitioner has, comma, in the meanwhile, comma, taken admission in one of the private institutions. So, considering the stand taken by the DMET, the aforesaid stand which has been taken by Mr. Mohanty has not been disputed by learned counsel for the petitioner. So, in such view of the matter, this application is disposed of with an observation that if any vacancy arises, comma, the petitioner's case may be considered by the authorities for admission in a government institution.
My serial is 46 and my learned serial
Based on merit.
So what I pray, my lord, my learned serials submitted that 23 seats are lying at hand.
No.
Oh my.
23 have been filled up.
37 out of 23 has got that.
No,
23 seats are filled up. There are 23 seats are earmarked for the green card that has been filled up.
The council, 23 seats are
I
there.
don't tell Mark.
Candidates up to 37 have been given that benefit.
Mark.
Your position is 46.
46.
So therefore,
so maybe
so Mohanty has also submitted that the it is a mistake
no. Kumar has been written as KU.
that there is a that the typographical error
What is difference? He is not going to put the technical,
like
like Kumar in the green. What his case was that it was not being considered, I mean, your objection that, so we'll say that that should not be considered and he will be considered in the green card category. That Ku and Kumar, what you were saying, so that will not be taken into account. He will be considered as a green card holder as per your vacant seats or whatever, all right?
yes.
Item number 10.
From the other side, I find that entry application because I don't stand in the way. Let that be allowed. Let that be allowed. They filed an interim application to recall that order of 1211. Modified. And instead of
The appropriate authority is the government, my lord.
I'm not standing in your way. I'm agreeing with you.
Please address us.
I'm not standing in your way.
Please address us.
So, Milords, as per your lordships, kindly have a look, kindly come to the interim application. Your lordship order is quoted there. Your lordship has,
He has to give us that interim application, we don't have it.
Yes, please.
and second part is Milords, they have.
Whether the amount has been paid or not.
No, amount has not been paid. It has been wrongly computed on the basis of his having retired as a DSP. But actually is retired as an additional list. That is one part. Second part is that the 7% interest that has been granted by your lordship, for which your lordship passed an order dated 12/11, that has not been calculated. Now this IA has been filed to recall that order and direct the opposite party number 2 to comply with. And I'm not on, since they have said that, let it be. I'm not
Who is
standing in the
opposite
way,
party?
I concede to that.
Who is the opposite partner?
mean, Milord is the home, additional chief secretary come home secretary. And that DSP should be altered to additional SP Milord,
Because
because
that we will not go into that. That they will decide. We will go by the order only.
Lordship, may kindly come to Annex 2 of my contempt petition. It is the order, there is the order. 38, page 38. Lordship's order is quoted therein at page 38. Also, they have quoted your Lordship's order and another judgment of this Honorable Court relating to the self-same petitioner. Last para, page 38, last para, Annex 2 of my contempt petition.
This is another order you are saying, same order?
No, there was an original application filed.
So that was dismissed.
No. Lordship, may kindly come to page 38, Annex 2.
Have we got a copy of the code?
OF was disposed of on 4/4/2014 with observation that the applicant is not entitled to any relief. Last line of paragraph 3. Thereafter, you filed it application
Milords.
challenging that order.
Milords, no.
Let us see the order of the court.
Lordship, may kindly come to page 38, para 4, Annex 2 of my contempt application.
Page 10.
Paragraph, just.
Milords, para 4, Milords. I have got a copy of the order also of this Honorable Court.
We also have it.
And no, that OA order.
Okay.
And whereas the tripartite preferred WPC number 989788/2014, the contempt petition arises out of this. Before the Honorable Orissa High Court challenging the orders dated 4/4/2014 of the Honorable Tribunal, passed in OA number 514/2012 with
Which is the paragraph? Which is the paragraph of the order?
I have given the order, Milords. I am sorry, I just had only one copy. I have given the.
No, where is that 7%? Which paragraph?
7% Milords is of the paragraph 46. Paragraph 46,
Just a
Lordship may
minute.
kindly come to the interim application.
Just a minute.
Paragraph 46,
Just a minute.
Annex 1, page 9.
Just a minute. All right. Now let us know, because now you have taken a stand that it is not the DGP, but someone else has to sanction. Very good. We are happy. Come to paragraph 46.
No. It's open to release the petition and gratuity in full to the petitioner. Yes,
All right. Who sanctioned the pension?
only the government.
Government. So why did the government not sanction the interest? All right. We are initiating
We have
contempt.
taken the stand, Milord, that it is under the process.
All right.
It is under the process. It takes its time because
No. Sorry.
it's a stage-wise sanction, Milord.
Sorry.
My lord.
Sorry. Now we hear the order.
Milord, 1 week more time be granted, Milord.
We'll give you enough time.
1 week more time be granted, we will comply with the order.
Petitioner in the written contempt application has alleged intentional disobedience of this court's order dated 5/7/2023.
Yes.
5/7/2023. Passed in WPC number 9788 of 2014. To the extent it relates to to the extent it relates to payment of interest on the amount of pension and gratuity which was payable to him. So paragraph 46 of the said order reads as under. So this matter was earlier taken up on ten 9/2013. For 24. It was the 12/11/2024. Noticing the admitted non-compliance of this court's order, it was opined under the impression that the Director General of Police, Odisha, is the sanctioning authority, the court had required him to be, whether the amount has been sanctioned or whether it is present or not. Why?
Because the application here.
Where is the application?
Any exemption? Will you find any exemption? Okay. Said to be sanctioning authority, he shall be. The court had required him to compute the amount of interest and sanction for payment. Else he would require to be, else he shall be personally present in court to face the charge of contempt. And interlocutory application is sought to be filed on behalf of the who has filed?
SP Kala.
Stating that he is the sanctioning authority.
No. Stating that the government is the sanctioning authority. Superintendent of Police Kala handed.
He is OP number 3.
He is OP number 3.
Is sought to be filed by OP number 3.
I'm saying OP number 4 below.
OP number 4. Taking modification of the order dated 12/1/2024. To the following effect. The fact remains that the order of this court has not been implemented. That the Chief Secretary, State of Odisha, file an affidavit stating as to disclosing the name of the person who had sanctioned the pension and gratuity in favor of the petitioner without computing the amount of interest as was directed by this court. The post of the affidavit must be filed. The Chief Secretary shall be required to disclose the present address of the person who did not take into account the order of this court, take into account the interest which was required to be paid to the petitioner in terms of this court's order. Top, list this case 1 week as the first case. Top, the court will consider passing appropriate order on on the interlocutory application which has been filed today. So we take notice of the fact that the Director General of Police has not filed any application for exemption from his personal appearance. We'll see later.
Item number 11.
Can it be taken up next week on them?
What do you want? What do you want?
Next week,
Next week, every time you are seeking adjournment.
Second, your lots of posing the question that by line senior and island retopic number 1831, that the authorized the consultant, law consultant is not competent enough to file the affidavit and retopic before this honorable court. The technical point has been raised by my land senior that authorization has not been given. We have sought for that authorization letter from the office.
As requested on behalf of the applicant, this matter on 4 weeks. Yes.
Item 12.
Compliance of your lordship's order dated 5/11/24 on 19/11/24 filed a demand draft of 1 lakh rupees as cost and directed by your lordship. Copy of that memo is there with me, my lord. This is a case, if your lordship will recall,
Yes.
that your lordship was pleased to set aside the order of the single judge only on the grounds that the UCO Bank regulations, pension regulations, that was not in compliance of that, though your lordship had accepted the findings of the single judge on merits. There was no fault in the disciplinary proceedings, neither was the punishment disproportionate. But thereafter, when I sent this for compliance, there in this review petition, it seems that they have already complied and there was a communication gap between the zonal manager who filed and the general manager who was the competent authority at Calcutta. That document I have already filed. But the lordship was pleased to
Issue notice. So what is the order? Order dated
order
7/8/2024.
7/8/24 with appeal number 1981 of 24. It's at annexure 5, page 219.
You can't even bring the petition, the petitioner was not informed about it. He was aware on record, you can't say that you knew you did not inform. That is why the problem.
Current counsel appearing on behalf of The petitioner states that in the light of this court's order dated 5/11/2024, an amount of rupees 1 lakh has been deposited in the name of the registrar, the executive judicial of this court
19/11/24.
on 19/11/2024. Of the said order dated 5/11/2024 takes into account the circumstance in which the aforesaid order was passed and is being reproduced herein below. Most often. Considering the facts noted in the said order dated 5/11/2024, in our considered view, prima facie case is made out for a review of this court's order dated 7/8/2024. Also, issue notice of 1 week,
No.
4 weeks. Meanwhile, the order dated 7/8/2024 passed in WA number 1981 of 2024 shall remain in abeyance.
And I'll take notice by register. I'll take.
Usual, registered or
Or
speed post, whatever. We are indicating that will be disposed of at the stage of admission.
Obliged.
Fixed deposit.
19.
Dear,
19 is correct.
19 is correct. They have invested on.
Item 13.
Pursuant to the last order, an affidavit has been filed by the Tehsildar. Paragraph 6 of that affidavit, page 2, if I may read.
30. 1 thing.
Yes.
Para 6 reads that it is humbly submitted that as revealed from the record of RMA lease number 4 of 21, the case record has been returned to the Tehsildar with the following noting. They return the LCR to the Tehsildar to process by obtaining mining plan, environmental clearance, etc. from the competent authority, since it has not any bearing on the judgment. Next paragraph, my lords. At page number 3, last 4 lines in paragraph 7, page number 3.
Where are you reading?
Para 7 at page number 3, last 5th line from the bottom of that paragraph. It starts from however.
No, I just missed somewhere. Which connection?
Not the annexure, my lords, the affidavit itself.
Affidavit is not there.
Dated 25/11/24. It was filed on 25th.
It is not there. But when did you file?
Today is 26th.
Yes, my lord, it was filed yesterday.
So you filed yesterday?
Yes, my lord.
All right.
Appeal is pending or disposed of?
Whether appeal is pending?
There's one line mentioned that the petitioner's appeal stands disposed of.
Well,
There's no date mentioned here.
appeal is pending.
Huh?
Appeal is pending.
But my lords, the records have been sent back to the Tehsildar, and thereafter it has gone for a mining approval and environmental clearance.
Last to the page 48 of the report.
Allowed then.
Let's see.
You check.
Page 48.
No, what we have to consider, because we had asked for personal
Appeal
appeals.
is pending. During LCR was called for. Appeal is pending, and during pendency of the appeal, he has returned the LCR for obtaining the mining lease. For permission, what
Well, if I may request, if it can be kept.
Receiving the LCR along with the mining
It
plan.
can
No.
be kept at 2 o'clock or tomorrow. I can give the.
Tomorrow?
Yes, no, that's tomorrow.
Page 40, it's clear.
Tomorrow, let it.
Along with the affidavit filed yesterday.
Copy of the affidavit.
Then you see, and so it states that a counter affidavit has been filed on 25/11/2024. This said affidavit is not there on record. Let the registry ensure that the affidavit is placed on record. Let's push matter tomorrow. Yes.
Affidavit or counter affidavit?
It's in the form of affidavit.
Item 14.
Counter. Affidavit. Counter.
Please, Your Lordship. Your Lordship, I'm challenging the order dated 16/12/2021 passed by the Collector Jajpur, Your Lordship.
21.
Yes, Your Lordship.
24, you are challenging it in 24.
Your Lordship, the order was not implemented, Your Lordship, due to heavy protests by the.
Where is that order?
Should file, Your Lordship. Your Lordship, I'm partially challenging the order with respect to the direction that I had prayed for, that a direction may be given to the collector to allow
No,
these.
but how can you challenge this order of 2021 in 2024?
Your Lordship, since the same was never implemented, Your Lordship, until today, the previous order was in force in which the decision was being followed and implemented. However, now this decision, the present collector, Your Lordship, has decided to implement the order, and the big truck owners are being allowed to take the minerals, transport the minerals inside the district, which is contrary to the decision that I have annexed in Annexure 1, Your Lordship. Lordship may kindly see.
Just a minute. In which proceeding the order was passed?
Your Lordship, in pursuance to the order of this honorable court to consider the grievance of the petitioner, this decision was taken, Your Lordship. And it was never implemented, Your Lordship.
No question of implementation. You could have challenged it in 2021. You could not have waited for the implementation.
Your Lordship, at that time, there were heavy protests as a result. The then collector did not implement the order, Your Lordship.
No question of
There was-
implementation. There was an order against you. You knew that there is an order against you. You are challenging that after 3 years.
There was no cause of action, Your Lordship.
Cause of action was then when the order was passed. Cause of action was not after that. Cause of action was when it was communicated to you.
Your Lordship, I have come, I'm invoking the extraordinary jurisdiction of this honorable court.
Maybe.
With substantial justice.
May no substantial justice.
I've accounted for the delay, Your Lordship, in my petition, wherein I have stated the same that I submitted before Your Lordships, that since it was not implemented, the previous order was being implemented. Your Lordship. The previous order that's in Annexure 1. All these decisions were taken on the representation of the petitioners, Your Lordship.
No, you could have challenged it.
Your Lordship, since it was not implemented.
No question of implementation. You cannot wait for an order to be implemented before you challenge that.
Your Lordship, now, the present collector is implementing this order. However, it was passed in 2021. The previous collector never.
There was an order against you. They did not implement it. Till they were not implementing it, you did not have any grievance. Now, since they have started implementing, you are.
Because we had approached them, Your Lordship.
No,
And they had, the previous collector had agreed to it, Your Lordship. Since it.
No, we are not aware. There must be some contempt application for which they may have complied, though we are not aware of that. So we must put to order of this. So how can we do it?
In the present.
Your Lordship, Your Lordship may take up this matter next week. Your Lordship, I'll come back.
On what ground? What purpose?
Come better prepared to assist, Your Lordship.
No, nothing. There cannot. An order was passed in 2021 on your representation. The order was against you. You did not challenge that. You are coming in 2024. How can you maintain? What explanation can you have?
That I gave, Your Lordship, that it was not implemented. But Your Lordship may grant me one more adjournment. I'll take further instruction and I'll assist Your Lordship.
No, madam, sorry. The
Your Lordship may take up this matter 2 days after, Your Lordship.
All right, Monday. Monday.
Okay.
Item 15.
And 15, Your Lordship, on the last day, direction is given to the opposite parties to file an affidavit, Your Lordship, regarding the stage of the appeal. It was submitted that it has been disposed of.
Yes.
My lord, today only we are filing the affidavit. Your Lordship may kindly call the matter tomorrow. I will explain what is the position and status, because the statute has gone massive amendments and the appellate authority has been changed in the meantime. In the wrong forum, he is pursuing his appeal, my lord. It should have been filed before.
What about the order? Order passed by the right forum?
Order, my lord, order by the then competent authority passed the order. But subsequently, the appellate authority changed, but because the sub-collector is no more the appellate authority. Therefore, the appeal should be filed before the director. I will show the statute.
So if you return the appeal, she'll file.
Yes, my lord. Will that sub-collector will return the file? And,
No, that is up to you.
Lordship may also direct, my lord, because it's a wrong file, wrong forum. After the amendment, my lord. I will explain you. Lordship may kindly call the matter tomorrow. We will be filing affidavit today itself, my lord. The officer has come, affidavit is ready. We will file it.
Requested on behalf of the state. This matter tomorrow. Then the AGA has stated that it shall be filing a counter affidavit or affidavit? An affidavit?
Counter affidavit.
Counter affidavit in court of the day. Of come on Thursday. This matter on Thursday. Let the counter affidavit for my file be placed on the court.
Kindly show a copy on her.
I saw the copy.
Item 16.
Please, Your Lordship. In the case of my price adjustment towards escalation amount has been approved, my lord. That is 13 March 2024. So till date, they have not released the inaction of the authority, and there is no arbitration clause, my lord, for which after the come out. Annexure 1, Your Lordship, page 13, Your Lordship. Subject is approval of adjustment data. The work name is there. And this was approved as per the government office memorandum number 3rd February 2023.
Third?
The approved on 13 March 2024. Annexure 1, Your Lordship.
Why are they not releasing?
Yes,
No, why?
For which I lost it from.
Yes, state.
All this they have to come to the High Court. The executive engineer will not release something which they are entitled to.
Affidavit. Counter.
2 weeks. Time is allowed for the state by counter affidavit. Just to
Can it be
2 weeks.
3 weeks?
3 weeks.
Item 17.
I am a lessee of a mining lease and I am carrying on mining operations. Now, my lord, we have a set of rules called the OMPTS rules. And my lords, the OMPTS rules provide for passing of some orders under those rules. Now, it so happened, my lords, that there is a state level enforcement squad. They visit the mine on 2 dates, 26th of June 23 and 27th of June 23. The lordships will get all this, at page 64. So what happens is, they say that we find a shortage of material which is about 0.014% of the production and 0.17 of the dispatch. But I'm really not on there, just to tell you, Lordship, the facts. And what they do, if you Lordship now kindly turns to page 64 minutes. What they do, they impose certain dues, certain demands, which your Lordships will get, my lords, at Annexure A, page 66.
Yes. Yes.
So if your Lordship sees, my lords, the first one is cost of ore in that chart.
This is Annexure 4, page
Annexure A at page 66.
66.
I'm sorry, my lords.
Yes.
If your Lordship sees, my lords, there's a table which says assessed government dues on surface. Your Lordships have it? That table at Annexure A, page 66.
Yes.
Now kindly see, my lord, the first one is cost of ore. Your Lordship may only write there, my lords, it is referable to section 21(5) of the MMDR Act. The next one is royalty. And royalty is section 9(2) of the MMDR Act. The next one your Lordships will see, my lords, is called DMF, and that is referable to 9(b)(5) of the MMDR Act.
Yes.
And the next one is NMET, which is 9(c)(4) of the MMDR Act. And my lord, the last one is premium, which is also rule 13(1) of the auction rules. So therefore, my lords, none of the demands have been levied under the OMPTS rules. That's the submission to your lordship. So what I do, my lord, I file a revision before the revisional authority. Now, what the revisional authority says, that because there is a mention of Rule 10(5) at page 65, 10(5) of the OMPTS rules, or in other words, he says, there is a violation of Rule 10(5) of the OMPTS rules, this revision application is not maintained. And your Lordship may straight away come to page 142.
Yes.
Lord, 142, if your Lordship sees, when I filed the revision, this is the order passed. The case was listed today for hearing. The revisionist was represented by so-and-so. The state government was represented by so-and-so. Advocate, under secretary so-and-so, heard under counsel for the revisionist, counsel for the state. The matter will be heard on the issue whether the revisional authority has the power to decide in such matters pertaining to violation of the provisions of the OMPTS rules 2007 and the demands raised under 21(5) or section 9 of the MMDR Act. Am I clear, Millers? He is saying that, look, this whole exercise was undertaken under the OMPTS rules, but the demands have been raised under section 21(5) of the MMDR Act. And therefore, that is what is to be decided. And my lord, the order comes at page 155.
Yes.
And if my lords are kindly pleased to see paragraph 2 at page 155, there is something here. In the instant case, the state government inspected the mine and found a shortage of so-and-so in the books of account of the state government assumed to have been dispatched. Lord, that's very important. There's a finding that the demand is based on assumption. That's the first point, although I am not there for the moment. Now kindly see paragraph 3, what he says. Since, and wait, let me read it, has been dispatched without taking prior permission of the competent authority, violating the provisions of Rule 10 of the OMPTS Rules 2007.
You are reading which paragraph?
I'm sorry, that's paragraph 2. Let me read again.
Paragraph 2, yes.
In the instant case, the state government inspected the mine and found a shortage of so-and-so in the book of accounts of the state government, of the books of accounts, which the state government assumed, your lordship only underline that one, assumed to have been dispatched without taking prior permission of the competent authority, violating the provisions of Rule 10 of the OMPTS Rules 2007. Your Lordship may stop here for a moment. No penalty has been imposed under the OMPTS. That's a fact. Your Lordship saw that chart. Let me read further.
Yes.
And Section 9.2, Your Lordship saw 9.2 of the MMDR Act, read with 31.1 of the Mineral Concession Rules. And the next paragraph, what he says is, since the cause of action has arisen because of inspection carried out by the state government under the OMPTS rules, where it found shortage in the quantity of mineral, the undersigned heard the learned revisionist and learned counsel for the state government as to whether the revision authority has power to decide such matters. And so saying, my lord, if your lordships kindly come to page 158.
Yes.
He says that paragraph 9, central government does not have power to revise any order passed by the state government or any of its authorized officers as per the rules made under 23C, that is the OMPTS rules. In my considered opinion, the undersigned does not have the power to look into the provisions of the OMPTS to decide the legality of the action taken by the state government for violation of individual rules under SWENS. And so saying, he says that I am not competent to decide this revision. This is dropped and you go to the appropriate authority. Now, number of cases are being passed like this. One such matter went to the Delhi High Court. And that order, your lordship will find it at page 182. Annexure 13.
Yes.
My lord said, Annexure 13, page 182.
Yes.
The petitioner has filed the present petition assailing the order dated so and so, passed by the revision authority under section 30 of so and so, 30 of the MMDR Act 1957. The petitioner contends that the demand which has been impugned before the revision authority can only be traced to section 21(5) of the MMDR Act. Therefore, the view taken by the respondent in holding that they cannot exercise the revisional powers under section 30 is erroneous. Issue notice. Now, I will show you, lordship, the two provisions under which you relies. Lordship, make us first see, my lord, section 30 of the MMDR. My lord, says section 30. My lord, this is author section 30.
Yes.
The central government may, of its own motion or an application made within the prescribed time by an aggrieved party, A mirrors, revise any order made by the state government or other authority in exercise of powers conferred on it by or under this act with respect to any mineral other than minor mineral. So therefore, mirrors, if an order is passed in respect of a major mineral under the act, then it is revisable under section 30. Now, am I clear there? Now let us see what is the power under rule section 23C. Because here the question is whether 30 will apply or 23C will apply. That's the short question. If my lords are kindly pleased to see 23C minutes. My lords have 23C, just 2 pages before.
Yes.
Power of the state government to make rules for preventing illegal mining, transportation, and storage of minerals. My lords have it. Now kindly see 23C3. Notwithstanding anything, my lords have it. Notwithstanding anything contained in section 30, the central government shall have no power to revise any order passed by the state government or any of its officers or any authority under the rules, OMPTS rules, minutes, made under subsection 1 and subsection 2. Lord, may I read it again? Lord, may I read 23C again? power of the state government to make rules. And in our case, they have made a rule called the OMPTS rules. Now kindly come to subsection 3 minutes. Notwithstanding anything contained in section 30, the central government shall have no power to revise any order passed by the state government or any of its authorized. Yes.
Yes.
Therefore, the question is, if your lordships now come back to the demand notice once again, which your lordship saw at page, your lordship saw at page 64, and let us see the chart. Is there any provision under these rules to levy royalty? The answer is no. Any rule to charge DMF? The answer is no. Is there any rule to charge annuity? Answer is no. So therefore, milords, even though it is nomenclated as a proceeding under section 10, all the demands pertain to provisions under the MMDR Act. The only reference is that there is a violation of Rule 10(5) of the OMPTS rules. Now let us see what, although there is no demand for that, let us see what is OMPTS rules. Milord, this is the book. Your lordships have the same book. Kindly come to page 209.
Yes.
Now, milord, if your lordship sees 209, Rule 10, my lords will get at 217.
Yes.
Milord, 217, Rule 10 is with respect to transport of minerals, which means you have to transport a mineral under a particular form. And 10(5), my lord, your lordships will see over the page at 218.
Yes.
And my lord, if your lordship sees what is the violation under these rules, assume, my lords, I have violated this rule. That's the highest they can say. Let us see, my lord, what is the penalty, and that your lordships will get at 229.
Yes.
The maximum penalty, my lord, under these rules is rupees 5 lakh post conviction. May I read it? Whoever undertakes or causes to undertake illegal mining, we are now on transportation, let us assume it's correct also, or stores any mineral otherwise than the provisions of section 4(1) and
Which
4.
section? Which
Milord, section, I am reading
Oh.
rule 18 at
18,
page
yes.
229.
Yes.
Whoever undertakes or causes to undertake illegal mining, transports or stores any mineral otherwise than with the provisions of section 4(1) and 4(1) of the Act, is punishable with the imprisonment for a term which may extend to 2 years, or which may extend to 5 lakhs, or with both in case of continuance of such illegal activity, with any additional fine which may extend to 50,000. So my submission to your lordships, there are certain penalties prescribed under these rules. Now, those are outside the view of section 30 because of the proviso to 23C. But a demand is referable to the MMDR Act, like say royalty, DMF, DMET, etc. Because under these rules, no power has been vested with the state government to impose penalty or impose any royalty, etc. under these rules. So in my humble submission, lords, this revision was maintainable and the authority should have decided this revision.
We will file an affidavit. But so far as the law is concerned, it is the divesting of power by the revisional authority. If he has the power, he has divested his authority. On that question, Lord, I have to go through the statute and
Central government.
Central government, but state government is also stakeholder because it says that the
Central government is a party.
Central government
is a party.
Because the order has been actually, my lord is right. It's an order passed by the revisional authority. My lord, there are large number of cases which are going to come now. Therefore, your lordships have to decide it, because whenever the state is writing Rule 10 and demanding royalty, etc., which are all referable to the Major Act, it is now being sent back. Earlier, it was not being done like that. And I am told, my lords, one matter is already pending. JSPL. before your lordship. Slightly on a different fact.
Again, the order passed by the revisional authority.
Revisional authority, he went back and he was not given copies of the on natural justice slightly different than this. So your lordship may issue notice, may not let them file a counter and.
Please, it is listed for first time. I will take instruction, my lord.
I take notice for OP 2 to 4, my lord. 2, 3 and 4.
On behalf of. Oh, you are representing?
For OP number 1, Ministry of Mines.
One. And you are
1.
2, 3 and 4.
The state rule 2, 3 and 4.
How many opposite parties are there?
4.
4 opposite parties are there.
Except no.
My lord, in that GSPL matter, your lordships have said no coercive action.
No coercive. Oh, Mr.
That's what your lordship.
It is listed for first time, lordship. Before
I
passing.
leave it at
See, Mr. Parija,
I leave it at that.
the situation here is different.
I leave it at that. Your lordship will only say, my lord, notice on stay also. We'll see as and when something happens.
It's fine, yes.
Appeal.
I know.
4 weeks?
4 weeks.
1 week for
Yes.
rejoinder.
This is matter on 5 weeks. So as to some time in the meanwhile may be utilized for the petitioner to file a rejoinder to the counter affiliate.
But actually, the counter of Mr. Padhi will really decide this issue.
Affidavit is filed.
Grateful.
Oblige, my lord.
Number 18.
With your lordship.
Lordship, challenging BDA's inaction, Bhubaneswar Development Authority, Lordship. Bhubaneswar Development Authority is in action in releasing my outstanding dues as regards the.
Which item? Yes.
Lordship, I am the highest bidder and entered into an agreement with BDA for shifting of the electrical goods from Big Bazaar Patia to the Patia station. The annexure 2 is the agreement, your lordship, and I have
Annexure 2.
successfully completed the work, which is at page 98, your lordship, annexure 10, where the executive engineer of BDA has written to the TPCODL that the work has already been completed. Because after completing all the formalities, I presented my final bills on the 20th of June 2024. Yet they are to take.
Which power should be exercised? Power of the executive chief engineer or the secretary, departmental? These bills?
Bills are submitted before the executive engineer.
Yes.
BDA, they are pending.
And there is no forum in the agreement.
No, your lordship, no, your lordship.
You could have filed a suit then.
Lordship, they have already given me till the 10th running account bill. This is the final bill, your lordship. But going to a civil suit will take a huge time altogether, and your lordship, every month or so, the executive engineers are retired persons.
Here also, and High Court, 2011 matters are pending.
Lordship, I bow down, lordship. They have agreed to my, at page 92, your lordship, annexure 8, they have agreed to that my bills are proper. They are not disputing my bill. They are keeping on delaying the matters on some ground or the other, asking me to submit some documents which I have already submitted.
No, but this is of August 2024.
I have completed my work since 2023 October, your lordship.
23?
2023 October.
So you are entitled to get money in November 2023.
No, I submitted my bill in the month of June, your lordship, after the entire measurement work.
When?
In 2024 June.
In 2004 you are saying July. Where are your bills?
No. My bills I have submitted.
Very wonderful. You submit your bills in July 2024. On 3rd August 2024, some communication is there. And when did you file the writ petition?
Well, 20th of June, Your Lordship. 20th of June, I submitted the bills, Your Lordship.
Yes.
Yes, Your Lordship.
And thereafter, see, on 3rd of August, there is communication, submission of work completion, so and so.
Yes, sir. That is already been submitted.
And you have come in October.
Your Lordship, that is the, they used
That
to
is
pay.
therefore, how do you say that this is inaction?
Well, that is election because, Your Lordship, at Annexure 8, Your Lordship may see, they are asking me for completion of certificate, which they themselves have acknowledged at Annexure 10, Your Lordship.
All right.
Page 20. Something, does that apply to you? Clause 16. In case of any dispute or any other reason, decision of the engineering member, BDA, that doesn't apply to you.
So there is no dispute, Your Lordship. There is absolutely no dispute.
Then why have you come here?
No, the dispute is that in spite of submitting all the
we want
documents,
the
let notices we issue.
We are dismissing it with certain observations.
I may be given a liberty
That
to
you
file a
can
fresh
have.
representation
That
for.
don't repeat it. What do you want?
Lordship, I will not miss the application with the liberty to file fresh
Counsel
representation.
appearing on behalf of the petitioner after some argument seeks permission to withdraw this application with the liberty to pursue his remedy before the authorities. Of this application is disposed of accordingly with the liberty and so on.
Item 19.
Please, Your Lordship. And here the petitioner is assailing the legal and arbitrary fresh tender call notice of e-tender for advance sale of cashew nut of cashew plantation.
What happened? What happened?
Here the petitioner is assailing the illegal and arbitrary fresh tender call notice of e-tender for advance sale of cashew nut of cashew plantation. My lord, here the tender has been published on 7/10/2024, my lord. And on the petitioner already deposited all the formalities, my lord. And on 1/11/2024, he has the tender sale notice was issued on before on the 4 of opposite party number, my lord, 4, my lord. He has only offer price of only 4,000. My offer price is of rupees 1 lakh, my lord, which I have annexed, my lord.
So therefore, they have come out with first tender notice.
They have called upon the first tender notice, my lord.
Participate.
But the tender is on date has been fixed to 20 and 21, my lord, of this month, my lord. Only if you will I have already participated in this, my lord.
So when was the first tender notice issued?
On 5/11/2020.
Why did you not participate?
I have participated, my lord. I have participated, but they have already issued that and fresh tender against me.
participated.
My lord.
That the result will be published soon.
The result soon, but on the first tender con notice, I have.
Their tender, they can do what they like.
See, first tender notice was issued against which you had participated. Thereafter, they cancelled this tender notice, first tender notice. They issued first tender notice. In that also you participated. Then what problem do you have?
The only thing, all the bids, that was, you have not been selected.
No, my lord, I have not been selected.
Have. And it is for, one sec. Why have you come here?
The petitioner in the presented application has put to challenge first tender call notice number 21014/OFDC -169/2024 dated 5/11/2024 for advance sale of cashew nuts of cashew plantation field in respect of bracketed A lot number 2025 / cashew division, Bhubaneswar. Division answer.
Notice that
Also, it appears that the petitioner has participated, you have participated?
No, my lord.
Has participated in the tender process pursuant to the set first tender call notice dated 5/11/2024. So, in such view of the matter, we are not inclined to interfere in the present proceeding for two reasons. Firstly, we do not find any illegality in issuance of first tender call notice. So, secondly, the petitioner has already participated in the first tender process without any objection. So, the application stands disposed of. Yes.
Item number 20.
Because of your representation, they have published this press notice. You should be happy. So why did you come here? It's okay.
Well, there is a petition called notice at page 8 annexure 1 mirror by the OC number 3 for hiring of vehicle, new vehicles mirror. So I have applied and I have been selected, and that is 1 year. For due to their need, they have entered into agreement with me for 2 years mirror. First, we kindly see the agreement at 11% at base 10 mirror. The motor vehicle is hereby hired for 2 years at the rate of 30,900 per month, excluding GST every month, and the mileage of the vehicles which will be governed as per the final department OM number such and such. The contract will be renewed subject to satisfaction of the principal mirror. When this contract is existing mirror, all under sudden they have issued a termination of the contract at annexure 5 page 16 mirror. Only within 7 months.
Where is the period prescribed? What is the date? This agreement is dated?
Agreement is dated
14/3/2024.
Agreement is dated 27/2/27. 14th March, madam.
14 March.
14th March.
Yes, what is the, where is the period prescribed?
That is on the same page 10 mirror, 3.0 mirror, and the motor vehicle is hereby hired for 2 years.
No, as per the notice.
2 years.
Which clause?
Clause 3 mirror, 3.0. Page 10.
This is regarding one vehicle.
Well, one vehicle.
There is clause number 12, resolution of disputes. In the event of any dispute or difference relating to interception and or application of provision of this agreement, such disputes or difference shall be resolved in mutual consultation by the secretary of the concerned administrative department on behalf of the government of Orissa and the authorized signatory of the service provider. Should be mind, which is because the initial contract period was for 1 year.
Yes, ma'am. Quotation is for 1 year, but agreement is made 2 years. Only 7 months has been passed.
Where is the order?
At page 16, Lord, annexure 5. . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . . .
Let us see clause 6.1.
Madam. The principals have the right, shall have the right to terminate this agreement upon it giving 1 month notice in writing. That is the clause, madam. But the quotation period is for 1 year. Madam. Quotation period is for 1 year. Madam.
No, no, that is not. Even before that,
But
6.1 is very
that is the
clear.
reason.
Huh?
People also see page 8 million.
Come to 6.1. See, someone cannot be compelled to continue with the
That's
vehicle
true.
if
That's
that is
true.
not required.
That's true, Miller. But I am unable to, in the mid of the period, Miller.
Huh?
That is contract quotation is for 1 year, Miller, 2024-25. And for their requirement, they have made it for 2 years, agreement for 2 years.
But that annexure 4,
Correct?
annexure 4. Probably in view of that, they have cancelled that.
Yes, Miller.
Authorization is for 1 year.
One officer, yes, Miller. One officer issued quotation notice for 1 year and they entered agreement for 2 years. Another officer issued notice to terminate the contract.
Terminate the contract because they don't require it. It is not that they require and they have terminated your agreement in order to have agreement with someone else.
My submission is Miller.
It's come, annexure 5 is very clear.
Miller.
The division has no requirement of private vehicle for use. That is the reason. How can we compare?
Yes, Miller. But that they have stated, Miller. But if you also see the agreement, Miller, quotation is for 1 year, Miller.
No, that we have
They
understood.
require, so they entered into agreement for 2 years because they require it. They require it, so entered into agreement for 2 years.
Suddenly the requirement is not there, the project is over or something. Can we compel them?
No, at least for the quotation period, Miller. They continue for quotation period 1 year, Miller.
What for? If they don't require, then your vehicle should be parked because there is an agreement.
But the OP3 says, Miller,
All right.
for their requirement, they extended it to for 2 years, Miller. They entered into agreement for 2 years instead of 1 year.
Rate application has put to challenge. Challenge communication dated annexure 5.
23, 2024.
Terminating the contract of hiring a private vehicle for UK Irrigation Subdivision 3, Boriguma, for the year 2024-25. So, it is the Land Council appearing on behalf of the petitioner has stated that the petitioner has responded to a quotation call notice issued on 27/2/2023 for providing vehicles. So, top. The petitioner had participated. So, top, though as per the quotation call notice, comma, the period. Where is that?
Page 8, Miller.
Page 8, which clause?
First, serial number 1. For the year 2024-25.
For 2024-25 governance. For year 2025 4-25 only, comma, an agreement was entered into between the petitioner and the superintending engineer for providing the vehicle for hiring the vehicle for 2 years at the rate of 30,900 per month. Approx. In the midway, comma, the or later dated 30/10/2024 has been issued by the Superintending Engineer UP Irrigation Division, Borihuma, terminating the agreement with effect from 1/12/2024, invoking clause 6.1 of the agreement. Next, learned counsel appearing on behalf of the petitioner has submitted that the petitioner should have been allowed to provide the service for at least for a year from the date of agreement, comma, as per the all notice.
Is any period mentioned in that quotation?
Yes, the
Call notice?
Yes, ma'am.
quotation,
Very
quotation, call notice. Stop. Next, we do not find any merit in the present writ application in view of clear stipulation in clause 6.1 of the agreement, which specified as under colon dash what the principal shall have right to terminate the agreement, comma, upon it giving one bracketed ONE month notice in writing. Stop. Evidently, in terms of the said clause, notice was given to the petitioner. A notice has been issued to the petitioner who later dated, impugned later dated 30/10/2024. Top. It has been mentioned in the said letter dated 30/10/2024 that the division in question does not have any requirement of private vehicle for use, both of in such circumstance, no interference is required by this court. The application is accordingly dismissed.
May I submit it?
Adding of vehicle within the quotation notice period, quotation called notice period, comma, the petitioner's case should be considered for hiring his vehicle in view of the fact that there was an agreement between the petitioner and opposite party number
Superintending engineer is.
Three, AP3.
Yes.
What were you saying? That. You said you wanted to say something?
If there is a dispute resolution clause, that I was.
That was open to you.
Then it will definitely.
If you will go there, then this last.
The petitioners are also we are liberty to invoke the dispute resolution clause under clause 12.
12 of the agreement.
Clause 12 of the agreement, which is dispute resolution clause.
Item 21.
7.
Item 22.
Due to your lordship not extending the approval by PCI.
We have given NOC.
NOC has been given by the immediate authority, but the approval has not been renewed, but the approval has not been given by the PCI on the ground that I haven't got the affiliation from the State Board of Pharmacy. The State Board of Pharmacy affiliation can only be procured when I get an NOC or renewed NOC. NOC was renewed in the month of 11/7/2024. Thereafter, I got the affiliation from the State Board of Pharmacy on 12/10/2024. The PCI has rejected my application in the month of October 2020. So I could not have produced the same certificate before the PCI.
What can be done? We cannot put the clock back.
Your lordship, but again, they have not adhered to their own guidelines, which prescribes that the inspection has to be conducted. Without conducting an inspection, they have rejected my application.
So what relief can we grant you?
Lordship, at least they should consider my State Board of Pharmacy affiliation.
Who?
PCI, Union of India.
Even if that is considered, then what will happen?
They have to, because they haven't adhered to the procedure which has been laid down by their own guidelines.
Therefore, we are putting this question, what will happen?
That rejection has to go.
The rejection will go and that will not serve any purpose.
Rejection, if at all, your lordship, rejection will be there. Then I cannot conduct any kind of admission, or I will not admit any kind of
So
student.
this academic year, you cannot do anything.
Your lordship, that is the problem.
That is the problem.
It's a fresh course.
Your lordship, it's a fresh course. And in fact, they haven't adhered to their own guidelines, which mandates that the inspection has to be conducted. Without conducting an inspection, they have rejected my application. And the second thing is, I could not procure the certificate of renewal application or affiliation, which was pending before the State Board of Pharmacy. And on the similar situation, they have renewed, they have given the approval to other colleges without having affiliation of State Board of Pharmacy.
In the rejection order, they say attention is invited to the judgment of the Honorable Supreme Court.
No, your lordship. Annex 7 is the rejection letter, your lordship. 30th of November is the last day. It is not yet over. 30th of November is the last day. Rejection order speaks of Odisha State Board of Pharmacy affiliation has not been provided.
October 31st, 2024. Appeals and compliance till November 30th.
Your lordship.
All right. So according to you, this order is illegal.
Your lordship.
Annexure 7.
Your lordship.
How?
Lordship, on the ground that there are procedures, may I take your lordship to...
No, come to see. Let us go step by step.
Yes, sir.
Annexure 7 is what?
They have rejected my application on the ground that I don't have affiliation of Odisha State Board of Pharmacy.
You did not submit the statutory document.
Your lordship, that could not be provided because my NOC was not renewed.
Therefore, see, there is nothing wrong with the order. They could not have passed any different order than that has been passed.
They could have inspected my college.
Who?
I have given a letter to the authorities that my inspection, my NOC is pending, my affiliation is pending before the state government. So state government was considering my renewal of application at that point of time. And thereafter, after I got the NOC from the state authorities, I applied for the affiliation from the State Board of Pharmacy.
You're saying it's a fresh, now you're saying...
You'll see it's a phrase.
You're saying renewal?
NOC renewal. NOC renewal was pending before the DMT authorities.
No, but when was that granted?
That was granted on 11/7/2024. I got the affiliation on 19/10/2024. That is at Annexure 5, page 41, Your Lordship.
Got the affiliation on?
19/10/2024.
Oh, so this was rejected on 30th September 2024.
Uh,
You have approached us because thereafter you have got the permission.
Your Lordship.
Nothing is wrong with this order.
Your Lordship, they have rejected my application on 12th October 2024. I
Before
got
the affiliation was granted.
19th October, Your Lordship.
Therefore, on the order was passed on 12/10
Your Lordship.
and affiliation was granted on 19/10.
Your Lordship.
On 12/10, you did not have the affiliation.
No, I didn't have it because my application was pending before the state authority.
Are you sure that the decision was taken on 12th or it has been communicated on 12th and the decision has been taken on 30th?
12, it has been communicated to me, Your Lordship.
The decision has been taken on 30th.
But again, my application was pending. That is at Annexure 5, page 41
Pending
for affiliation.
the necessary documents before them, so they didn't have a choice.
Lordship, on the similar footing, when the affiliation were not, when the colleges were not having the affiliation, they have been granted the approval for the academic session. And the law mandates that by the PCI itself. Your Lordship.
You have not given the statutory documents. Has the last date for application elapsed?
Lordship, what has happened is I have filed NOC is a mandatory requirement for getting an affiliation.
We have understood when you filed the application,
Lordship.
that is not there with you.
Your Lordship.
Mr. Counsel, this is what we had decided. In the last academic year, NOCs were granted.
Your Lordship.
After the last date of admission were over.
Your Lordship.
That was the case.
No, my lord. This year.
Judgment.
Yes, yes.
For the previous academic session, 2023-24,
The timeline. was
you
given.
had granted affiliate NOC after the last date for admission was over. You remember?
It's in some of these cases.
The judgment which I delivered fixing the
Yes.
In the month of May,
in the month of May. So there also NOCs were granted. NOCs that they did not they were not at all relevant.
Your Lordship, what has happened on the similar footing? There are 3 to 4 colleges where NOC was not granted and it is still pending before the concerned authorities. Now approval has been given, provided by the PCI. That is
For approval by the PCI,
Your
what
Lordship.
fees do you have to deposit?
3,67,000.
No, that is not the question. See, Mr. Counsel, whether this order is legal or not, this is one aspect. If this order is legal, and if you have to file another application, then we will have to go by the rules. So once your application has been rejected, then you cannot file a fresh application.
No, I'm not saying that I'll file a fresh application. I'm saying that the rejection order is bad in the IF law, saying that they haven't followed that, they haven't adhered to the procedure as laid down by the PCI, as well as the guidelines laid down by the PCI itself.
Let us see the PCI guidelines.
Your Lordship. And additional affidavit I have.
Additional affidavit will not do. Will not do.
Because the rules and regulation have incorporated in that, Your Lordship.
Rejected, what is the procedure?
Once my application has been rejected, there is no alternative procedure except to approach the High Court.
Just
Your Lordship.
curiosity. Your application has been rejected on the ground that you don't have statutory documents.
Only
In the
affiliation.
meanwhile,
Your Lordship.
whatever, in the meanwhile, you got the document.
Your Lordship.
Is there any bar for applying again?
If at all, I'll apply, they are not going to consider because the inspection part cannot be done within 3 days. That is on 30th of November is the last day.
So can we set aside the order today after setting aside the order? Can we direct that it should be granted?
Let the PCI obtain instruction on this.
It's not possible. Do. Notice go. Who is appearing for PCA?
Yes, you know, available.
Issue notice.
Your Lordship, may I
See,
pray-
you want us to do something which is impossible. You cannot do. And it is happening. You have one institution, therefore law cannot be changed.
Your Lordship, may I take to the procedure which has been laid down by the PCI?
But can we set it aside without?
Yes, Your Lordship. Yes, Your Lordship. May obtain instruction, but again, 30th of November, I cannot admit any kind of students.
Issue notice.
Lordship may take up after lunch. I'll satisfy Your Lordship regarding this regulation and rules, Your Lordship.
Therefore, we have issued notice, otherwise we would have rejected it. Yes.
Your Lordship may fix it.
It's impossible. We cannot.
Your Lordship may short date.
Sixteen of 2024.
Why didn't you make a mention in the morning?
Your Lordship, I came from all along Rourkela,
Give
so
us-
I could not able to reach.
Please give us. Please give us.
Your Lordship, the urgency in this matter is the petitioner is a student. The college given information that.
I'll personally see your slip. You have mentioned the urgency. Also. Bail application, why are you mentioning here?
Your Lordship, yes, bail application. It's not coming on the list, even if there is an order of oblige.
For admission item number 1.
May I please, my lords, with my lord's kind permission, I'm through VC. I'm for the petitioner.
I thought Advocate General is standing before us. All right.
Such a nice compliment. I have been receiving these on and off now. Not can be sometimes 16th, 17th of December.
16, 17.
What is
As all the matters. A question on behalf of the state. List this matter on 17. 17.
Great. Three orders there, let them function. Great. Progress. Great.
As well as my representation and the affiliation which has been provided later at the consent.
What is the Supreme Court judgment?
Annexure 8, Your Lordship. Annexure 8, it has been provided all the compliance.
You're saying the last date has not gone, so maybe they can consider.
How can they
They have
consider?
set aside, maybe they can-
How can they consider?
It has been extended by a Supreme Court, the Honorable Supreme Court,
Then 30th,
30th of November.
yes, this is November.
So I have approached the PCI on 24th and 26th October.
Then you withdraw it, pursue. See, we cannot ask them unless we cause that order.
And withdraw taking into consideration.
Counsel appearing on behalf of the petitioner. seeks permission to withdraw his application with liberty to pursue his matter before the Pharmacy Council of India in view of the changed circumstances. Changed circumstances.
Affiliation as well as
And
affiliation made by the State Board of Pharmacy.
affiliation has been granted by the State Board of
Odisha State Board of Pharmacy Law.
Odisha State Board of Pharmacy. And Odisha is already.
Item number 39.
Last order and affidavit has been filed. And as Principal Chief Secretary, Conservator of Forest is in this court with the fracture. Mr. Dr. Nair is online. He's the Chief Conservator of Forest Wildlife. He was also assisting before in these.
In this case,
Have you filed your affidavit?
Yes, my lords, it was filed today morning. I have extra copies also if my lords want to.
Oh,
Not the affidavit. This is the affidavit.
Affidavit. It was filed today morning.
All right. So it has already been e-filed.
Yes, it was. And I'm told it's reflected in the.
Sorry?
I'm told that it's already reflected in your records, my lords.
Oh. Really? Item 59.
Of 1911.
What is the date of your affidavit?
25th 11.
25th. There is no date in the second part.
Apologies, my lords.
25th, all right. What you are saying is impossible. That we filed it yesterday, it's a tough on record.
That's what I had instructed so that it could come on record.
Right?
Oh, yes. Revolution.
But my lord, it was e-filed today morning.
Had you mentioned in the morning, we would have asked for it, then probably they may have got it. Without an order, it can't happen. Paragraph 13 of the order,
My lord says,
it is 1911.
yes, my lord. So the first, as per paragraph 13, the first detail which had to be produced was details of deaths in a tabular format.
As for paragraph 13, Principal Chief Conservator of Forest was required to join the proceedings online.
My lord,
And he was also required to file an affidavit.
My lord, sir, he is actually.
No, that is all right. But when once an order is there, what is the procedure that should be followed?
My lord, as the chief conservator of forest has filed this affidavit, and previously, in the connected matters,
We know that. He was in charge, everything was there. So that could have been suggested when the order was being passed. Or an appropriate application filed.
You notice the year-wise deaths of the elephants. In 2022 to 20, there were 50 deaths. 21, it seems 88.
My lord, at page number 59 of this affidavit takes details of number of deaths. 2020-21, it was 77.
Where?
Page 59, my lord.
59.
Annexure 3.
Yes.
That's 2021. We have mentioned with reasons. What is the cause?
77.
Yes, my lords. In the top, we have mentioned the reasons of deaths also.
Other is maximum.
Others is maximum. And my lords, the JPF was formed in September 2022. Thereafter, these things are getting regulated and number of deaths have started, has substantially reduced in number.
Elephants also number must have reduced.
No, my lords, fact is that number of elephants have actually increased in 2000.
That is why they come into the villages. Is that the reason or because of the natural habitats?
My lords, because of the topography of the state, the
Twenty-four, 25. Because this electrocution, 21 have already died.
Yes, my lords.
That's for them or for other animals? Like in this case, it was for the boars.
This was specifically for boars. My lords, there's annexure 4 wherein we have given.
Boars, I don't think such powerful.
My lords, the thing was that it was because of illegal cooking is the main reason.
So that is why from that high tension wire.
Then they have put in the bamboo pegs and the wire have been put for basically killing of wild boars. And there the elephant have unfortunately
No,
been
that is
trapped.
understood, but to kill an elephant, like this intensity will not be as
No,
much
my
as
lords.
required for the boar. So that is why I was wondering.
My lords, even a 11 low tension line can kill a elephant because the size of the elephant is huge. And that, yes, my lords. Mr. Manoj Nair.
Please explain. All right.
What have you stated in your affidavit?
My lords, first,
You must tell your officials that if there is any direction that has to be fully complied with. If there was any direction that Chief Conservator of Forest, whosoever is to join, either he should have joined or he should have made an application.
I apologize for that.
This is amounts to showing disrespect to the court's orders.
I apologize for that.
If this is the practice in the state of Odisha, then that will have to be changed.
But mainly because,
Because this is the second instance.
but only because he's with a severe ankle fracture.
No, he could have just, or anyone,
Understand.
any officer of the department could have filed an application. This is circumstance. It is not that we want to see his face and therefore. Yes, what have you stated in your affidavit?
Yes, my lord, as per the last order.
We make it clear that it is not that we believe that you are less interested in protection of wildlife than the courts. So you are equally, your officials, they are equally been concerned about it. We just want to know and if required, we shall be issuing appropriate directions and guidelines. So this is the purpose why we had.
At 2 days time, I'll file an. My lords have granted me 2 days time, I'll file an appropriate application for.
That is, we are not very. So who has joined for the?
My lords, Chief Conservator of Forest, Wildlife, Dr. Manoj B. Nair is online, my lord.
Yes, Mr. Nair. Nair.
Yes, sir. Sir, Lordships, good afternoon, sir. This is Dr. Manoj Nair. I work as the Chief Conservator of Forest Wildlife, Your Honor, in the office of Principal Chief Conservator of Forests and the Chief Wildlife Board in Odisha, Your Honor. I have been appearing before your honors regularly in the past, Your Honor, as in my capacity as the chairperson of Joint Task Force, Your Honor. So it's my privilege to be submitting before you the actions that the state has been taking in a very, very targeted manner in the last 2.5 years, ever since this joint task force has been formulated and formed and acting in the field, Your Honor. With your permission, if you would kindly allow me, Your Honor, I would very quickly touch upon the what steps that we have been adopting in order to minimize the conflict of humans and elephants, and specifically the elephant and human deaths, Your Honor.
Yes. Please.
Your Honor, with your permission, just like to flag, 3 points. This question of human-elephant conflict, Your Honor, has been particularly acute in this East Central population. Out of the 4 populations in India, Your Honor, is East Central population is beset with acute conflict. And that, Your Honor, is because of the lie of the land. Unlike South India or the Western Ghats, where you have intact forests and the edge of the forest and the crop fields are almost a straight line, here in Odisha, it's almost in a state of it's complete admixture of croplands, cultivated lands, and other areas. Your Honor, am I audible, Your Honor? Because I lost.
Yes, we are hearing you.
Yes. Thank you, Your Honor. So here, if the data has to be analyzed, Your Honor, it becomes very evident that about 15 years back, the elephants were largely confined to intact forest areas and in about half of the districts. But over a period of time, they have started moving around quite a bit, showing erratic movement patterns, moving quite out of the designated elephant corridors and elephant movement areas. Your Honor, when this whole question was being heard before your honorable selves a few years back in 2023-24, we had, under the directions of your honorable court, we had formulated a committee, a joint task force, which was mandated to prepare a comprehensive action plan, Your Honor, which was duly prepared, adopting all the best practices taken from the whole of India, and led by acclaimed elephant expert Dr. Raman Sukumar of Indian Institute of Science. Now he's an emeritus professor there and an acknowledged Asian elephant expert, Your Honor. Sir was kind enough to guide us and to brief the court himself. And Your Honor, I would just like to flag a small point in this regard, that they had been commissioned to do a study on carrying capacity of elephants in Odisha, Your Honor, in 2018. And the results, the report is there with us. And
Which capacity you heard? Which capacity? Carriage capacity?
Carrying capacity.
Your Honor, it's carrying capacity, which essentially means that how many elephants the state can hold, Your Honor. It's an ecological concept. Therefore, they had undertaken a very exhaustive study, and the operative part clearly mentions, Your Honor, that the state in its current ecological integrity and pattern can harbor or can hold about 1,700 to 1,800 elephants, Your Honor. And at that point of time, till very recently, elephant population estimation, Your Honor, the census is being conducted in a all India level manner. And the last census was, Your Honor, carried out in 2017 throughout the country. And according to that, Odisha had about 1,970 odd elephants, Your Honor. But after 20... Yes, Your Honor. Exact figures I can just furnish, but it's roughly that amount, 1,970, if I remember correctly, Your Honor. But because that was a figure of 2017, and the Honorable Court had rightly observed that you need updated figures to do any sort of evidence-based policy making, we ourselves, the state of Odisha, ourselves embarked upon a population estimation in the May of 2024, Your Honor, a detailed exercise conducted throughout the state. And we have currently a figure of about 2098, Your Honor, 2098, around 2,000 elephants, Your Honor. And that was the summer census. And normally, because water is a limiting factor, Your Honor, elephant population estimation is carried out during peak summer, that is May. And according to the figures that we have in the May of 2024, this year, we have about 2,000 odd elephants in Odisha, Your Honor. And what happens is that, Your Honor, winter population estimation is also equally important, because elephants from other states come in due to crop seasons. They come for elephant depredation. So currently, ma'am, both Your Honor, Lordships, we have just completed the analysis of the winter season also. And the final figures we'll be producing before your kind selves, but it is again roughly about 2,100 odd. So it is a consistent figure, which essentially, Your Honor, means to say that probably
the carrying capacity of the estate of 1,700 was found to be in 2017.
2018, Your
that
Honor.
Also
2018.
Also variable or what?
And
That
Dr.
also
Nair,
varies.
this carrying capacity, how much was it before 2017?
Ma'am, Your Honor, it was not estimated before 2018, Your Honor. It was the first time that a carrying capacity study was attempted anywhere in the country, actually. And they have come out with a figure for Odisha. Your Honor, I would also like to flag before
so what are the main factors for determination of this carrying capacity?
Your Honor, they have taken facts such as the forest area.
Two, three only.
Yeah, crux. The crux being, Your Honor, the forest area, intact forest area available, the habitat quality, and Your Honor, most importantly, also connectivity and availability of water sources. So connectivity is a very important concept, Your Honor, because they require large open landscapes which are connected through intact forest. So over a period of time, what has happened is there are a lot of developmental activities of various kinds, including linear infrastructure, roads, expansion of railways, etc., etc. So which has also caused the elephant herds to sort of split and move in a phenomenon called fission and fusion model. So they will be just splitting, Your Honor, and moving into different places. Crop season, they again come coalesce and go together. So this is also one of the important reasons.
So is this your suggestion that whereas the carrying capacity is reducing, the number of elephants has increased?
Have increased, Your Honor. Have increased, Your Honor. It's significant. Yes, Your Honor. Yes, Your Honor.
So even though the number of deaths have increased, the population is also been increasing.
It's on the increasing trend, Your Honor. Ma'am, it's on the increasing trend. But one thing I would like to flag, Your Honor, and ma'am, in this particular context is that electrocution, Your Honor, is proving to be a real problem for us. We are trying, if you look at the comprehensive action plan, Your Honor, we have formulated a very nice strategy based on 10 vertical themes, which includes possibly everything starting from interdepartmental coordination, high-level committees, habitat modification, protection through squads, infrastructure upgradation, and also, Your Honor, very importantly, crop ex gratia payment revision, which after many years was carried out in Odisha. But the challenge for us, Your Honor, I'll be very, very honest and frank before you and submit before you, is this question of electrocution, Your Honor. It's a huge challenge for us just because it is a very difficult question to tackle, Your Honor, as the electricity penetration increases to the last mile, which is an undeniable right for everyone, Your Honor. I completely admit we also want electricity. But in the process, Your Honor, the surface area that an elephant herd is likely to come into contact with a live wire has gone that much more. And one more, Your Honor, if you give me 2 minutes, I'll also tell you that for tackling electrocution, a separate chapter has been put in the comprehensive action plan. And one of the important steps that we were taking was what is called rectification, Your Honor, which means earlier the deaths were largely due to sagging wires, slanted poles, etc., which caused elephants to come in touch with them. But the state of Odisha has almost spent about 800 odd crores and has handed over to the 4 discoms, to Tata Power, and TPCODL, TPNODL, TPSODL, and TPCODL has taken up 4 phases of rectification, and a good work has been done with substantial amount of expenditure, which has, Your Honor, drastically reduced accidental electrocution due to faulty electrical infrastructure, Your Honor. But unfortunately, what has happened now? A practice of deliberate electrocution has started, Your Honor, primarily driven by 2 things, Your Honor. One is for hunting of wild boars, and second for crop protection of small croplands. So the marginal farmers and sometimes even orchard owners, what they do is that they will just hook it onto a live wire, and then put a string of wire, 2 strands or 1 strands around their crop fields, primarily for crop protection against wild boar and maybe other small animals also. Till now, Your Honor, we have not come across any place where they target elephants. Luckily, the social carrying capacity of Odisha, unlike some of the other states, still tolerate elephants, Your Honor, and that is the reason why you still have elephants roaming around in our forest and forest fringes. But this menace of deliberate electrocution for targeting wild boar, Your Honor, is a real issue, and that is something which we are grappling with, Your Honor, with all sincerity. And we have put forward a lot of steps, reworking our strategy. But this is something which my humble submission is that all the discoms also need to take up very seriously, and in partnership with the Forest Department, we have to tackle it as a composite team, Your Honor. That is my submission and prayer before your lordships.
What about criminal cases?
Your Honor, I'm very humble and happy to mention to you that the poaching for ivory and poaching, deliberate killing of elephants have drastically reduced. And thanks to our massive deployment of elephant tracking squads, protection squads, elephants, infrastructure, etc. So elephant poaching is really not a problem, Your Honor, currently. It has been tackled substantially. Conviction rates remain very poor, Your Honor, we admit. And ever since the Joint Task Force has started functioning right now, we are hand-holding every single case of elephant death is being monitored at such a level that we ensure that for the first time in last decade or so, prosecution reports, peer reports are submitted within 60 days. We ensure that we vet it. We have inducted retired police officials into our Joint Task Force to ensure that case records are maintained properly. Capacity building workshops are being carried out, Your Honor. And I think in about another 1 to 2 years, one would see a substantial difference in terms of conviction, Your Honor. Unfortunately, conviction rates are very, very low. Most of the cases gets acquitted because, I would admit, because of loopholes in the case record preparation. And that is partly a lacuna because of inadequate capacity. And Your Honor, we are strongly addressing that issue. And the High Court was also, Your Honor, been very kind to us by designating certain courts as the special courts where wildlife cases have to be tried. And that is a recent development, Your Honor, and that will further give a much needed fillip to the entire prosecution, Your Honor. We are very thankful for that.
Where is that action plan?
Your Honor, action plan is there. We have already submitted to all. Yeah.
Part of the affidavit is on the record also.
It's there on record.
We submitted on 17 January 2020.
What happened in that case, the recent one?
Your Honor, the last case which happened on the 18th of November 2024 was a very unfortunate one where 3 elephants got electrocuted at the same time, Your Honor, which is a rarity.
Occurrence we know, but what happened thereafter?
Thereafter, what happened, Your Honor, was that we were, immediately in all cases of electrocution, Your Honor, we send a team from the headquarters from the Joint Task Force. They reached the spot within a few hours because it happened in Sambalpur in a place called Nattidyol. I myself was there on the spot, Your Honor. I would like to submit before you. And we have immediately, in about the space of few hours, 4 suspects were identified, Your Honor, because it was a clear-cut case. They could recover the pegs that were used for illegal hooking. They could recover the wires. They could find out the place where it had been hooked on to the 11 kV line. And the whole area was a very, very, very susceptible spot for such kind of electrocutions, Your Honor, with a forest edge, clump of rice fields and a forest on the other
What
side.
happened in the criminal case?
Sir, there have been 2 people were arrested, Your Honor. 2 people are absconding, and they have been forwarded to the Honorable Court, SDGF Court in Redakhol. 2 people are absconding, and we are tapping their their mobile connections and we hope to apprehend them very soon, Your Honor. Actually, and this is a very, very sure shot case for a possible conviction, Your Honor.
What is the stage of investigation?
Investigation, Your Honor. The ACF of Redakhol division has been nominated as the inquiry officer, and the investigation, Your Honor, is currently ongoing, and the rest of the 2 accused also we are hoping to track. And as far as evidence is concerned, Your Honor, the wires that were collected.
No, evidence we cannot. We just want to know whether charge sheet has been submitted.
It's a recent case, Your Honor. So we aim to submit it within another.
Is it a police case or what?
No, Your Honor, it is under the Wildlife Protection Act.
But must be registered at the police station.
It is registered with the range office of. We tried under the Wildlife Protection Act, Your Honor, and the
which provision?
Says under Section 9 of Wildlife Protection Act, Your Honor, hunting is a crime which can get a conviction of 7 years, Your Honor. So we have the case number and concerned sections also we have.
Case number 70 of the affidavit which we have not
Whether an FIR has been registered or not?
Yes, Your Honor, it has been.
First registered as a complete case and then it's converted into an OR case.
Yes.
The complaint, not FIR.
All evidences have been collected and it has gone for forensic laboratory in this matter. And expectedly, the reports will come to us in maximum within a month.
You also have to keep sight of the fact for the period you provided for completion of the investigation. The 2BCC number 18 of 2024 is the case. Document at page 70.
At the top, converted into OR case number 139 of 2024.
That is all right, but the complaint case also is there at subsequent pages where we have forwarded exhibits and all that. There the 2BCC case number appears.
Where is the penalty, Mr.?
Wildlife Protection Act. Wildlife Protection Act. Your Honor, we are just getting back to you.
$51.
There is that FIR number 188,609 of 1085. Which page? FIR number 188,609/1085.
Was that page number 70 at the top?
70.
Yes, my lord.
It's a complaint case.
It is on all your rest of your documents you have referred stating report. Subsequently, a FIR number so and so on 18/11/2024 was drawn, and one UD case number 3 was been registered. So there are two cases.
This is the document.
That is the UD case. Sorry, this is the POR case.
This is the UT case which was numbered at first and thereafter it has been numbered as numbered case.
What?
UD case 3.
Three that were converted to OR case one.
There's some FIR somewhere.
No, FIR cannot be registered. FIR cannot be registered, Mr. Ray.
That is the mention
What I
FIR.
was-
You don't
I
have.
can submit something. I was hearing Mr. Nair, he was saying a lot of things. One thing he said that they are having these debts because of electrification. So they are able to manage other things after this JTF has been formed, but electricity is an issue. Now, I have given a small 2-page note, including the members. So one thing, if because that JTF was formed because of the intervention of the court. So one solution now for preventing these kind of things in future would be having the distribution companies as a part of the JTF. That may resolve things to some extent. Because Mr. Nair did say that the main problem now is this electrocution. So let the distribution companies come on board, and then maybe we can take things forward.
Measures they may take to prevent
Prevent.
hooking.
Because hooking, both many of these, I'm appearing for one of the parties here who are affected by these electric. But the issue would be that to prevent these kind of, because private people are trying to protect their crops and they're having this electrocution. So that balancing has to be done by them and the distribution companies. Unless the distribution companies are more proactive, this can't stop. And the figures are quite staggering. I think 20 odd, if I'm correct, was because of electrocution. So now the main issue that they are now to go into is this electrocution.
Maximum offense is, punishment is.
Yes, Mr. Nair, this suggestion appears to be quite valid.
Distribution companies have been included as parties to this PI law.
That's right.
So they are all before your lordship.
That's right. But
Your lordship,
to go
your lordship, if I may be allowed.
Yes, please.
Your lordship, most welcome. The suggestion is most welcome, your honor, your lordships, because this is a collective problem, and till the ownership is taken by the discounts, there is, it can significantly make a dent in the issue, your honor, according to us.
So who can be brought on who are the?
Your honor, they've already been party.
I have given the members that are present there.
Have you already given it?
I have given it to your lordship. A 2-page note at the beginning. At page 2, the members are there. It's also part of their report. And my lord, I have given another copy.
Short notes.
Yes, short notes. Page 2 of that. These are the members. It's also matching with their task force names and all are there.
But nobody from the.
Nobody from the distribution company. From each zone, if they can have one each, and they have to be proactive in preventing this.
Your honor, most welcome. We'll be more than happy to have discoms, representatives of the discoms in the JTF. Very welcome suggestion.
They will.
They are also answerable since it's board constituted. JTF report constituted.
WTC 19625 of 2015, DISCOM is a party.
19 party and then
19625. In 2015.
Don't touch those. JTF, they put DISCOM. DISCOM people are not in JTF. Even my lord, the railway people also got into it. They are also.
They are giving suggestions that are not carried out.
So how many companies are here?
Four companies.
Four companies.
Four companies, Your Honor, four.
Based on area,
Zone
zone-wise.
East, west, north, south. Center. West.
And there must be a central company, something?
Yes, Your Honor. TPCODL.
Four separate companies.
We have a Odisha Power Transmission Corporation Limited, for whom I am appearing below. They look after the operation, maintenance, construction of extra high voltage substation and transmission lines.
This is for the entire state.
Entire state.
Even they can,
The companies.
so Tripathi, if he suggests, they can also be.
In fact, I'm there as opposite party number 13.
No, to the JTL.
JTL, we can, OPTCL can also become a party below.
Party is separate.
No, you're a party in 9056.
We are a party in the petition by lot 9056. They can also be taken in the joint task force by lot.
Mr. Mishra, you are appearing in 22421?
19625 2015.
No, sorry.
I'm
Which
appearing.
Mishra? Which Mishra?
No,
2421, I'm appearing.
I am appearing there.
So in this Dvija Dalpati,
I'm from, I'm for the petitioner.
the distribution company is there.
No, I think in Livanili party, in person, the distribution company is being. All matters, I think, were taken up together, common order.
Common orders are being passed. I just wanted to know which petition has them.
That is WPC 19625 of 2015. In that, they have been included as party.
Yes.
In that, my learned senior Mr. S.P. Mishra appears, being assisted by Lalit Kumar Mohan. For the
You are presenting whom?
Appear in that.
In that, he's for the distribution company.
For this one.
That is TPN or DL.
No, but we have one task force for the entire state of Odisha. How does it function?
Your Honor, we have one task force for the entire state, Your Honor. That is the joint task force, which is mandated to look at human-wildlife conflict issues, Your Honor. You're right, Your Honor.
Joint task force has prepared a comprehensive operation
Action plan, that is there.
Yes.
But better position.
Yes,
No.
PCL is government. And the problem is the startup power and they are private. So the problems are beginning from there because the number of deaths that have happened recently, I think there is some, what I gathered from him is that they're not able to check that. So let OPTCL along with all four be there. They are all
distribution company.
Now there are
much
forest
more
officers
focused.
and police departments.
joint task force.
Joint task force.
Only forest and police.
No, joint task force is
Only forest department and police department.
The comprehensive action plan, madam, they have given it.
No, that's second and call.
Correct. Forest and police and others are all individuals.
Yes.
Conservator, forest. Conservator, forest. Special additional SP. Raman Sukumaran, Surendra Mahanti, Rajan Panda, Aditya Chandra Panda, Honorary Wildlife.
See, just we want to know this. Like you have joint task force with chief conservator of forest, Deputy Chief Conservator of Forests to so and so, and then SP additional SP. So how do they monitor? Just we want to know that. How does it function?
Your Honor, if I may be allowed, Your Honor, I'll explain it in a minute.
Yes.
Your Honor, we have the JTF functions from the office of the Principal Chief Conservator of Forest and the Chief Wildlife Warden in Odisha. That is the place where I'm sitting, Your Honor, and I report to him. In this office, Your Honor, we have JTF consists of official members and non-official members, Your Honor. Among the official members, there are representatives from the Forest Department and the Police Department. The Forest Department officials are led by me in this office in the capacity of Chief Conservator of Forest Wildlife, although in additional charge. But I have a DCF who reports to me and who is part of the JTF again and who is present in the court physically, along with 3 range officers who assist us in analysis, documentation, field verification, inspection, etc. From the Police Department, Your Honor, we have an additional SP rank officer who is stationed in our office. He sits in our office full time as part of the JTF, and also 2 inspectors. So there is, although there are vacancies for more, Your Honor, because of the staff shortages, we have not been getting the full complement. In addition to the additional members, Your Honor, we have non-official members who are experts and conservationists from their respective field. The most eminent of whom is Dr. Raman Sukumar, who happens to be the preeminent expert, global expert on Asian elephants, Your Honor. Under his direction and his guidance, we have prepared this comprehensive action plan. It also includes certain public representatives in the form of honorary wildlife wardens from some of the districts, some people involved as wildlife experts, etc. And the JTF is also free, Your Honor, to co-opt anybody that we want to. From time to time, Your Honor, we have unofficially sought the consultations and services of a few very eminent individuals, including wildlife veterinarians for health issues, some of the wildlife crime experts to guide us in prosecution preparation, etc. Your Honor. So this body functions from this office. That is the office.
So just for the sake of example,
yes, Your Honor,
we can refer to the latest incident.
Right.
So this falls in which zone? Zone of the Western. Which zone?
Your Honor, it falls in Western. TPW.
Western.
Yes.
Western.
Power distribution.
That is TPWODL.
Yes, Your Honor.
And you have TPEODL, and likewise, no?
Yes, Your Honor.
TPWODL. Tata Power Western Odisha Distribution Limited.
Similarly, you must be having TPEODL, TPNODL, TPSODL. Likewise, no?
Your Honor, we don't have TPEODL, Your Honor, but we have TPCODL, that is central. We have TPNODL, that is northern. We have TPSODL, Your Honor, that is southern, and TPWODL, which is western, Your Honor. 4 in all.
So since the electrician is one of the biggest challenge before you, then why don't you have you interact with them, the officials of these companies?
Your Honor, we have been regularly interacting with them in an unofficial manner, Your Honor, but we will be definitely taking your suggestion. We will be more than happy, and we will co-opt the representatives immediately, Your Honor. Direction noted.
Yes, let us begin from there. Who heads or who will be the best suited official of these companies?
In fact, Mr. Nayak, because he is heading this JTF.
No, we will not include anyone in the JTF for the present. First of all, we will ask Mr. Nair to have a meeting with the officials of
CEO of DISCOM.
CEO.
Yes.
There are also general manager. But also in general management.
We will decide. And in that discussion, you can come out with a suggestion to the court that this person can be included in the JTF from either or from all of the discourse.
Noted, Your Honor, noted.
All right, from each of the
Company.
company.
See, you are representing the entire. Four C. So four CA. Four CEO in four different companies. Four. Well, this is a pre-mallet. The regional manager of the railway mallet, they must be included in mallet.
Let me see. Let us start from this first.
Your Honor, if I may.
Please say.
Your Honor, because all the distribution companies eventually come under the energy department of the state government, Your Honor. My humble submission is that any representative of the energy department also would add a lot in terms of fund provisioning, transfer, etc. Your Honor, just a humble submission from my side.
First of all, our opinion is that the CEOs must understand the problem which you are facing as the.
Noted, Your Honor. Noted.
They can discuss. And CEOs are private officials or?
Private.
They are private first. Privately engaged.
There is no
Private
government.
companies. No government.
Absolutely no government. Sharing this. Government and private sharing. Private. One more person can be added, rightly said, from energy department, because the government is usually to fund.
We are not doing anything, Mr. Minister, right now. We are just asking the Chief Conservator of Mr. Nair to have a meeting with these officials. Something shall emerge after the meeting, and thereafter we will decide who are to be added in the JTF. All right. This is what.
How it will function smaller, they have to give the guidelines also. How the JTF is functioning.
In the light of this court order dated of 1911 2024, the Chief Conservator of Forest.
Yes, Your Honor.
Mr. Nair is Chief Conservator of Forest and Wildlife. Direct Chief Conservator of Forest, bracketed Wildlife. One has joined the present online, joined online present proceeding. An affidavit has also been filed, shown by him in compliance of the said order. So, in the compliance affidavit, the dates and division-wise deaths of wild elephants in the state of Odisha from 2020-21 to 2024-25, bracketed as on 22/11/2024 has been provided in tabular form. First off, the said affidavit also contains, briefly, the number of death of the elephants. Also contains briefly the reasons of death of the elephant for the said period. So annexure 3 at page 59. So, referring to the figures of deaths, Mr. Nair has admitted, Dr. Nair has admitted that deaths of elephants by electrocution, either deliberate or intentional, is the area of most serious concern. So stop. Next, it is evident from the data provided in the affidavit that in the year 2024, 21 deaths of wild elephants have been reported out of electrocution. Twenty-three. So, 85 elephants in the state of Odisha died of electrocution from 2021 to 22/11/2024. Stop. This has happened despite this court's serious intervention, which led to preparation of an action plan and constitution of joint task force to protect the wild elephants in the state of Odisha. So stop. Next, Mr. Mishra, learned senior counsel appearing as an amicus curiae. Representing. Senior counsel has submitted that the court, that considering the circumstance that electrocution is one of the major reasons for deaths of wild elephants in the state of Odisha, inclusion of the representatives from the electricity distribution companies in the discoms in the state. So stop. whether that aspect has been taken into account in preparation of your action plan?
Yes, Your Honor, but not formally, Your Honor. We sought the technical inputs of the discoms because it is a technical matter, Your Honor, what kind of interventions could be made. So they did provide, particularly TPCODL being based out of Bhubaneswar had sent representatives. We had several informal parleys with them, Your Honor, not minuted, but their suggestions have also been accounted for in the chapter dealing with electrocution, Your Honor. Yes, they have been consulted, Your Honor.
Full stop. In the facts and circumstances, comma, to begin with, comma, we deem it proper to direct Mr. Nair, directs so and so, his position, Chief Conservator of Forest Wildlife bracketed 1, to convene a meeting of the chief executive officers of 4 companies canal. By what time? Within 10 days?
Yes, Your Honor.
By 10 days. To discuss, to ponder over the issue of deaths of wild elephants in the state of Odisha because of electrocution, and the remedial measures which can be taken by the state, jointly by the state and the distribution companies. Stop. List this matter on, these matters on 2 weeks. To be taken up at 2 p.m. Oh, stop. Mr. So-and-so will join. Shall be required to inform this court the outcome of meeting in to be convened by him in terms of this court's order. The court's order. No problem. Next. Let we also deem it proper to direct for impediment of all the 4 companies.
Already there.
They're in this matter? In the first case, in suo motu, they are not there.
Suo motu there.
In WPC number so and so.
28706 or 2020. I'm sorry, I committed a mistake. These 4 distribution companies, Tata Power has 51% shareholding, and the other 49 is government owned by Grid Corporation owns. That's Grid. So it's 51-49, Tata Power 51, and other 49 is by the government. So that's the share. I committed a mistake. And one line, if you can, Lordship can say, regarding the incident of 18th, they can submit a further report as to what has happened. 18/11/2024, these deaths occurred. After which suo motu action this was taken. So if they can also on that date say what further progress.
Oh yes.
Because that's something which is
so again shall be required to inform this court for the development in the case, in the complaint case registered in relation to the deaths of 3 elephants on 18/11/2020.
The 4 companies you can take notice since you are.
So accepts notice.
There should be present matter.
May I please your lordships?
It's on behalf of who? Because you are saying we are appearing, we don't know who's appearing for who.
The CEOs must be present, Malor. All the CEOs.
Why should they be present?
No, the PC is there, right? So they.
No, he'll be there.
Why CEO need not be present?
CEO is not required.
All the 4 companies.
Lordship, I am for the Wildlife Society of Orissa in the last sub-item. In fact, in this matter, in this sub-item, the order passed by Honorable NGT in an execution application has been stayed on the ground that
What has been stayed?
the order passed in an execution application before National Green Tribunal. In fact, Honorable NGT has passed an order after hearing for 5 years on 17th of August 2021, wherein the direction was to notify 14 elephant corridor within 2 months. That was the direction. Since they didn't comply, so there was an execution application in 2022. And to that effect, they have not complied. Since they have not complied, so for the National Green Tribunal Act is concerned, section 26 and 28, in case of failure to comply any of the order, there is a provision for prosecution and other things. So accordingly, Honorable NGT has taken up that matter of execution application. Now that execution application has been, the order passed in that execution application has been challenged before your lordship, saying that it is a parallel proceeding. In fact, if your lordship will see, the original order is of 2021, 17th August 2021.
By which order that order has been stayed?
Lordship may kindly see WPC 14057 of 2023.
Which petition?
14057 of 2023. My only submission before your lordship.
Just a minute. 14057. State had filed this petition.
Yes, lordship. State has challenged that order. In fact, the order is of 2021, original order, and it was challenged in 2023, but not the order in the original application, order in the execution application. Same has been challenged.
Where is the state? So have you filed any application for vacating?
Yes, lordship. I have filed an IA. Kindly peruse my IA 6983 of 2023 for recall of the order. This order has also a consequence, as your lordship could understand, that at least out of 14 elephant corridors, now at least 9 of the elephant corridors get degraded. And the region among the infrastructure, the other region is
just a minute. Just please wait. So very see, we'll have to examine this. Who is appearing in that case? State. You have challenged and Can you see that order, Mr. Mishra?
I'll apprise my lord what I don't want to join issues with the state and my learned friend. What had happened, I'll tell. Since the court was monitoring this on a regular basis, and what the experts suggested, those experts and the action plan was prepared. So there was a feeling of the court that both the orders, that implementation of that NGT order and this plan may not be workable together. That's the reason why this state had challenged it and the order has been stayed. So in this background only, I think the order also reflects that since both cannot run together, because if that order
You see, Mr. Mishra,
I'm just
again,
uprising that
speaking
this is
for
what had
myself,
happened.
I'm of the view that if the NGT is in session, if the NGT is dealing with the matter, then the
That is
Same philosophy, parallel proceedings, so why should we have?
my lords. In fact, originally that was the view of, but like your lordships have taken so amount of cognizance now.
so we were unaware of this,
Yes.
this proceeding and the order. All right. Mr. Pani, Mr. S.P. Pani, and counsel.
So this case has already been delisted.
Appearing for the Wildlife Society, bracketed opposite party.
Has your case been listed, Mr. Pani?
Yes, lordship. It keeps on listing before National Green Tribunal.
No,
but
here,
gets
here.
It is listed here at the last sub-item.
Yes.
Last sub-item.
Mishra, you said it is not listed, that is why I asked him, yes.
No, last sub-item it is listed.
Yes, we got it.
So funny, counsel appearing on behalf of opposite party, in WPC number 14057 of 2023 has drawn our attention to an interim order passed by this court on 4/5/2023. So he has submitted that an application has been filed. Where is your application for vacating the order? Okay.
Yes, lordship. My application is of number IA number 6983.
81 is 883. You're right. He states an application has been filed for vacating. They said interim order by IA number 6983 of 2023. So we make it clear that on the next date, we will take up WPC number 14057 of 2023 as the main case. As the first case, not main case, as the first case. Who is appearing? In that, apart from Mr. Pani?
In fact,
But please assist us.
IA was also taken up, and order number 15 dated, the order would be 9/5, not 4/5, 9/5/2023.
Just a minute.
Order number 15.
9/5, yes.
So, here the reasons have been given for the state, and para 11 also his IA was probably taken up. Seeking vacation and notice was is accepted. So thereafter, so this IA is there. There's been para 11 onwards, there is some discussion regarding my learned friend Mr. Pani's contention and the state's contention. Para 15, the court records that.
Paragraph 15.
Yes. And para 16, this electrocution has also been dead.
15 and 16.
And if your lordship would see that 17 would be crucial in the context of what your lordships have said today. Where there was discussion regarding solar fences.
So the similar orders were passed earlier
Yes,
also.
yes.
Exactly on the same line. That's just come.
And this crops up every time there is one such incident. It's almost like those other PIs, where your lordships, if the lordships take it up, then things move, otherwise they. I'm speaking generally, but that's almost.
All right. We'll see. Have a meeting, Mr. Nair, and then let us know.
Take 2
weeks. Yes,
You would appear in virtual mode. Your lordship may fix it at 2 p.m. on a specified time.
2 p.m. He shall join. You, Mr. Nair, you should join the meeting.
In virtual.
Noted, Your Honor.
Online.
We are grateful to you.
Item number 3.
Yes.
Well, the petition number 1. This is test 30 is that's 30 people. He belongs to modular community.
Majula.
Modular. Which is the OBC in the central list. And SCBC.
Mr. Patnaik, that certificate basically says you belong to the OBC, Majula, which is a OBC.
OBC. This caste also recognized as a SCBC as per the state list. It is a serial number 208. This is the state list of SCBC classes.
Then 2.
Then petition number 2 year lordship. He is the SCBC. He is the SCBC your lordship.
Page
31 of the bill. And his caste has been.
All these certificates are the year 2024 or there is some 21 also?
20, petition 224, petition 1, 224, petition 3, 21.
Petition number, how many petitions are there?
5 petitions.
3.
3 belongs to, he also belongs to SCBC. Also excluded from the criminal. And this certificate was in the year of 2021.
Yes.
And my lord, 5 is
4.
4 is also SCBC.
Yes.
He also excluded from the criminal. Notification has been added.
Yes. 5.
5 belongs to Sudhi community, which has been recognized as SCBC in the state list. Serial number 166 of the list.
No, whether you have the certificate or not.
My lord, while I am having this certificate, I produce the certificate before the other item, showing my caste.
showing your caste.
Showing that I belongs to the SCBC.
That is not enough.
Right.
In certificate, it must also be mentioned that you are not a criminal. You do not.
In certificate itself.
It is mentioned. All right.
In certificate itself, it is stated that I will, doesn't belong to the criminal.
All right.
Last for your lordship. Yes,
All right. All these matters related to admission to?
Admission to
BSc nursing.
Huh?
BSc nursing.
And what is your stand?
Not AG said that.
No. You.
Because we don't have SC, ST and SC. We are not previously having OBC. With my direction in a case, we have allowed OBC students to be taken into consideration, and we have made the.
No. Why are you opposing their case? Their claim?
Because they are SCBC. That's OBC. We will allow.
OBC will allow.
Yes.
No, OBC you incorporated because the court said.
Yes.
So now if we say.
Now, if as he told, this time we'll get the SCBC students so that next year the policy decision will taken so that it will.
Petitioner number 1 is OBC according to you.
Petitioner what?
No, are you saying that also SCBC?
SCBC.
Which does not have the certificate?
But does not have the
Yes.
SCBC certificate.
Hello.
He has also been included the SCBC in the state list.
You have included?
As SCBC in the state list of SCBC at serial number 208.
Petitioner number 1 belongs to Majula community, which is admittedly recognized as socially and educationally backward caste under the notification of the state government. Full stop. Petitioner number 2 3. Petitioners number 2, 3, 4, and 5 have the certificates issued in their favor to the effect that they belong to socially and educationally backward classes bracketed SCBC under the Government of Odisha, Department of Tribal Welfare Resolution number 20325, employment EMP dot bracketed Roman 7 -M -23/93, dated 28/1996 bracketed W, which has been published in Odisha Gazette. First off, the in the said certificates, the said certificates further certify in respect of petitioners number 2 to 5 that they do not belong to creamy layer mentioned in column 3 of the schedule appended to the office memorandum number 4030 dated 29/1/1992. Stop. Petitioner number 1 does not have such certificate of SEBC. Rather, there is a certificate, rather a copy of certificate that she belongs to OBC other backward class. Belongs to backward class under the Government of India, Ministry of Social Justice and Empowerment Resolution 12015 /13/2010-BC2 dated 8/12/2011. So stop. They have a common grievance in the present writ application that benefit of 40% of relaxation is not being extended to them in contravention of the guidelines issued by Indian Nursing Council in exercise of power under section 16 of Indian
INC Act of the Indian Nursing Council Act.
Why you have mentioned IWC Act.
INC Act.
So the
INC Act.
the Indian Nursing Council Act, 1947. So stop. The petitioners are also relying on look. The petitioners have a grievance that even the prospectus issued for admission to which course? BSc nursing course does not contemplate such relaxation for SEBC category candidates, despite there being provision under the INC Act. INC Act provides.
SEBC doesn't provide. That provides OBC.
This is his submission.
EWS.
This is his submission. Where is that Act?
INC Act, what the
INC Act cannot provide that.
exercise of this section 16 of that Act.
Where is that? Where is
The
that?
INC had issued the guideline.
Where is that?
That says
INC Act guidelines provided by INC. Yes, where is that?
case 36 Annex 6. Page 36, annexure 6.
Next, when counsel appearing on behalf of the petitioner has brought to our notice the guidelines issued by the Indian Nursing Council dated what? Which clause?
I thought I've given a path and order in 1638 of 24, dated 14/7/2024, where my lord has specifically mentioned about INC guideline and given direction to implement OBC.
Page 41, your lordship, that's correct. Page 41. The
Page
reservation,
41.
that guideline stipulates the reservation.
As far as I remember, no date was given in the
Page 41,
guidelines.
top here, that's reservation
Given a
policy.
date stating that it has been
I got it.
circulated.
Yes.
41 where?
Reservation policy, your lordship.
Hmm.
Reservation of seats for admission in nursing colleges for SC, ST, OBC, EWS, PH. Admission under the reserve quota shall be subject to reservation
Correct.
policy.
Clause 8 of the reservation policy,
If I may be permitted.
clause 8 of the guidelines reads thus. Yes.
Your Lordship, the Advocate General argued here the previous day. We are not, for reservation, we have our own state policy, Your Lordship, where the SCBCs are not given reservation. This is only for relaxation in the entrance.
Yes, we are not.
Yes.
Yes. Let's.
That he'll advise for next year, this year they may be considered.
And in fact, he is just seeking relaxation, nothing else.
Yes, yes. I am just checking the relaxation.
Point number 8,
7, Your Lordship,
Last
previous
page.
page 40, Your Lordship.
page 7.
40,
Yes, 40 last.
7,
7,
7.
Yes.
clause 7. How do you say clause 7? 40 percentile.
40%. Or reserve categories.
This is the only thing which you want.
Right.
Hmm. 7 quotas. Stop. Next. When counsel appearing on behalf of DMET. Could you get that order? Counsel appearing on behalf of DMET, Mr. Mohantil, and counsel appearing on behalf of the DMET has submitted that under the said guidelines, the relaxation can be provided to OBC candidates, not SCBC candidates. This is your
OBC and EWS.
OBC and EWS candidates and not OBC candidates. Oh, stop. So as to, we have on our request, Mr. Acharya and Advocate General address this court as to whether the persons belonging to SEBC under the state of Odisha can be denied the benefit of a relaxation in minimum qualifying criteria on the ground that they are not OBCs, as was contended by Learned Counsel for the DMET. So stop. Mr. Acharya drew our attention to the provision to Odisha Reservation of Posts and Services bracketed for socially and educationally backward classes Act 2008, which section 2 bracketed E of which defines socially and educationally backward classes as the backward classes defined in clause A of section 2 of Odisha State Commission of Backward Classes Act 1993. The backward classes has been defined in section 2 bracketed A of Odisha State Commission of Backward Classes Act 1993 as under 2 bracketed A. So stop. On conjoint reading, Mr. Acharya, referring to the provision under section 2 bracketed E of the Act of 2008 and section 2 bracketed A of the Act of 1993 has not disputed the position that SEBCs are the backward classes are such backward classes specified by the state government in the list who do not belong to creamy layer. So stop. Our attention has also been drawn to Odisha Professional Educational Institutions bracketed Regulation of Admission and Fixation of Fee Act 2007. Section 2 bracketed Y of which three bracketed, sorry, 2 bracketed y of which defines SEBC as socially and educationally backward classes of citizens other than scheduled castes and scheduled tribes as may be specified by the state government from time to time. So stop. The petitioners admittedly, now there is no dispute that we are of the view upon reading of the aforesaid statutory provision that the SEBCs in the state of Odisha are entitled to such a relaxation as is to be provided to OBCs in the guidelines issued by the Indian Nursing Council. So stop. Next. This writ application is accordingly disposed of with a direction to the DMET to consider the candidature of these petitioners as OBC candidates for the purpose of their admission to BSc nursing courses if they furnish relevant certificates in that regard. OBC, I cannot do anything. For OBC, we cannot do anything. SCBC, yes, you have everything.
We see that their notice of that might be covered in that. Because they have issued that. August, there is a notice.
Yes, that we are going to have a correspondence to it, added to this. I have already yesterday told them to get this notification.
Good.
So that by 30th, the admission is there, they will take up. I have already instructed it.
Can refer to that also.
So my note, so already uploaded today.
I'll try.
If it possible, so that I have already instructed them, so that I can give the.
I'll try to do it. We will try.
We took in 2484 of 24, maybe again to 4th December.
2484. Where is that?
In item 3, my lord.
So
That
that will come later.
That we have already adjourned to some date.
Monday, my lord, I adjourned it is.
I pray for a 4th.
That I think that has already.
Sir, ko dada
Jaini
ko
achi.
lagte 11th ceremony hote takare so that
Acha. They have gone for some obsequies, so on calculation that date he will be there. So you want on 4th?
4th.
Monday, 4th. Order here. Upon the birthday.
Okay.
Consent and list on 4th December.
Item number 23.
Opposing parties have proceeded tender for dismantling and erection of the high transmission line miner for dismantling and erection in different areas under the Iron Division of Bhanjanagar miner.
What do you want?
What happened, my lord? In the tender process, 3 persons become L1.
3%?
Become L1 miner. So they, as per the code miners, they invited to make a lottery of all 3 miners. They have fixed a date that on 12 noon, all 3 come, will conduct the lottery miner. On that date itself, my lord, I have faced a traffic jam in the Aska National.
Sorry.
Sir,
Sorry, sir.
Proceeding director also take the view I have not. I have intimated our court that due to traffic jam, there may be 10 to 15 minutes delay. Then in 12:10 I reached Minor. Within 10 minutes, the lottery was over. The tender was finalized in favor of the opposite party number 7, 2 jobs Minor. I am intimated to the authority. They have faced the traffic jam. That is the act of God. And this is also another act of the officer. Well, I am intimated. I have given the screenshot that you 10 minutes, my transport there.
All right. The lottery was held in the presence of?
They have conducted in presence of the officers.
All right. Where is that lottery notice? Where is that notice for lottery?
Well, that is page annexure 4, page 67. Well, it is totally tender has been fixed.
Tender has been fixed.
10 minutes,
Including the traffic
but
jam.
10 minutes by lottery cannot be
That.
funded.
It is fixed.
Well, let me see. They have stated that page 67 well, as per amendment of substances of applicable code, it is decided that one bidder shall be financed through transparent lottery system. In 10 minutes, everything has been completed. I have intimated that official that the 10 to 15 minutes shall take to delay 10 minutes, 10 to 15 minutes. Within 10 minutes, it has been abandoned.
You was there after 10 minutes.
At 12:10 I reached.
So you can.
By that time, they stated that when I reached that lottery job.
That you will have to prove in a court of law.
Well,
you will have to prove in a court of law.
Call for the proceeding. Actually, no lottery, nothing has been done, my lord. They have themselves finalized to allot. Well, what happened, my lord? The job number 1 and 2 allotted in favor of opposite party number 3, my lord.
All.
My lord, another bidder, my lord, he has been allotted to another job number 3, for which no, he has not participated in the lottery, my lord. Only 3 will be participating in the lottery, 2 present there. I am absent by 10 minutes. The job number 3 was allotted in his favor. 3 got job number 1 and 2 within 10 minutes, my lord. Without due, we have been duly intimated that you delay for 10 to 15 minutes. No, if you
Sorry, sir. Sorry.
call for the records, my lord.
Never. Dismissed.
Well, then because may I suggest one thing? Because this has been done by the subordinate officer, my lord. May I be permitted to the engineer in chief to consider my. If lottery was done, my lord, I have no case. He will examine, my lord.
Whether lottery was done or not done, whether you reached there after 10 minutes or you did not reach, whether there was any traffic jam or not. These are questions of facts which cannot be decided by us. This is just a minute. This is one. 2, you want an order to file a representation. You could have done that.
I have represented.
You do that.
I have
We will not
represented.
say. We will not say. You may pursue.
My lord, I have represented, they have rejected.
They have rejected that.
Well,
Then you file a suit.
they have rejected in Annexure 7.
Not a.
Annexure 7, page 71.
All right.
They have rejected.
We have our own limitations, sir.
My lord, so I know this is rejected by the person who has conducted the lottery. I am praying that let engineer in chief examine whether the lottery has been done or not. 10 minutes lottery has been over. Within 10 minutes. They know that I will be absent.
Item 24.
Yes.
Permit me to upload the engineer in chief, my lord.
That I will not. If you want, you may pursue. My lord,
you are liberty to upload.
counsel appearing on behalf of the petitioner. Just listen to the order. You will be happy. You may be happy. Then counsel for the petitioner, after having argued the matter vehemently, has sought permission of this court to withdraw this writ application with a liberty to pursue the matter before higher authorities. This application is disposed of with a liberty to the petitioner to pursue before an appropriate authority, if the law permits. Yes.
Another
Don't-
writ application I have given in the morning in the memo to 29,227. That is also
Lottery.
This is job number 1, job number 2. That record may be called for same order may pass.
You listed or not?
Not listed, I have mentioned in the morning mail.
All right. That will be listed.
Let it be listed tomorrow, same order can be transferred. It will
Tomorrow
also
to
call for-
mention.
And same order can be passed. In the
Tomorrow
same-
to.
But even the memo mail.
Number.
Yes.
Item 24.
24, Your Lordship, for the petitioner, Your Lordship, opposite party number 1 authority is setting over the very, Your Lordship's order since 2023.
For the first time it is coming below 3 weeks time if granted to file so calls.
It's already, Your Lordship,
Oh, where was the order passed?
it's passed. 11th, 04, 2023.
11?
11, 04, 2023.
So the order?
The order is page 11.
Correction of ROR.
Correct. Lordship, it is very, it's evidently clear that the honorable court has directed the opposite party authority to record the name of the petition and the ROR. But they're taking false claims and misleading petition.
Twenty-one. They have complied.
All right, let them file it. Few weeks time is allowed for the opposite parties to file compliance affidavit.
For admission, item 30.
Item number 1, serial number 1, I am appealing for the petitioner matter. But the sub item number 2, Your Lordship, WTC number 36084, in that case, I am appealing for the opposite part number 4 to 7, Your Lordship. I have to file counter, Your Lordship. Ordered may be fixed.
And counsel appearing on behalf of the petitioner in WPC number 3762 of 2021 states that she is appearing for the opposite party's number
4 to 7, Your Lordship.
4 to 7 in the connected matter, that is WPC number 36084 of 2022. She seeks adjournment to file counter affidavit in WPC number 36084 of 2022. As requested, list this matter on 3 weeks.
31.
That the instance of the state.
That's the batch of matters are pending actually.
What is that?
The issue in the batch is whether the appointment of DLRs prior to the cutoff date against the sanction post can be regularized or not. The High Court in the present matter has directed for regularization of the petition opposite parties on the very first date without there being any counter or
Argue.
information made.
That this matter will leave of the honorable court.
You are for the appellant.
No, I am the respondent. Yes, my lord, it is barred by time. I received the notice in the delay, my lord. I have filed my counter. And according on my mention, because I am the beneficiary of the imposed order, your lordship was pleased to consider my mention. Accordingly, it is listed. It was wrongly included in the batch. So, my lord, the question of limitation of the contempt.
What is the delay?
My lord? It is 396 days, and if the corona period is excluded, then also 100 delay. And your lordship, my counter paragraph 2, your lordship.
Counter to IA.
Yes, my lord. You know what? My lord, what happened? They diluted the order. The impugned order may not be considered, no longer it is my lord existing. And what happened, my lord, their conduct I have stated in my. When the impugned
See,
order.
there are two aspects. One, your condonation of delay application, and another merits. We are ready to hear on merits.
The question is regarding merit. What they are saying that they could not get any notice. Without issuing notice, a direction has been given. And for your lordship's consideration, my lord, when a writ application is filed, writ application, the subject matter is seeking regulation, DLR is seeking regulation. My lord, is covered with the decision of the honorable court and the apex court. My lord, the identical matters, the same order was passed, it is implemented by the state. This is the case, may be a solitary case, my lord, state has, my lord, appealed. So your lordship may kindly see what has happened, and when the writ application is filed, an advance copy is given, enabling the state to take instruction and address the court.
Mr. Counsel, the submissions which you are making, we can understand without any submission which you make. We understand that this is how the copies are served, but they have a right to reply to the petition.
They have been hard. They have been hard. And what happened? One more point, your lordship have raised for your lordship's consideration.
Sorry.
Let me submit 3 lines. Thereafter, your lordship, my lord. What happened, my lord?
These lines or 3 sentences. 3 lines or 3 sentences.
They rejected the claim. Tried to override the order passed by the honorable court. This honorable court directed for regulation. They said that the regulation is diffused.
Have you filed contempt?
I filed the contempt.
That is why they were compelled to file the writ appeal.
The contempt.
Because they have disposed of in their own wisdom.
That I have challenged. That I have challenged in the honorable court. This honorable court said that file the contempt.
This order cannot sustain.
It's the impugned order is at page number 18.
While considering the question of a limitation, merit is not supposed to be gone into.
That we will.
Honorable Court, Supreme Court decision, my lord.
Yes.
Merit cannot be gone into. That is the decision, your lordship may kindly for a moment see. My lord, their conduct is that even if the corona period is excluded in 100 days, I am not submitting regarding 100 days. My lord, during corona period, they are so alert. They, what my lords have said, they in their own way try to overrule and rejected the claim.
Well, that order or input order no longer survives for them to file the appeal. Because they have again challenged in the appeal, but they have themselves rejected.
All right.
So, my lord,
This application has been filed for continuation of delay in filing the present writ appeal. Stop. The office has reported 456 days of delay.
Stay was there.
456 days of delay. Stop. London Council appearing on behalf of the respondent has submitted that even if the COVID-19 period is excluded for the purpose of computation of the period of delay, there is delay of 100 days. In
About 100 days.
About-
they have not specified. They have not stated.
All right, they have about 100 days in preferring the appeal. Stop. He has submitted that no cogent reason has been mentioned in the application seeking condonation of delay. Stop. However, considering the facts and circumstances and the interest of justice, in our opinion, the case is made out for condonation of delay. Stop. IA number so and so. Delay is condoned. IA number so this application is allowed.
My lord, one more request.
Merit may not consider.
No, merit we are considering.
2 weeks after.
No, this is
What is pending before a batch, there is a batch of matters where the similar issues are pending. The main matter is WA number.
no main matter. See, this cannot be decided because this was decided on the first day, and the facts you were required to file counter affidavit. You can file counter affidavit. They'll give you liberty to file counter affidavit. An order of this court dated WS mentioned. An order of this court dated 6/7/2021 passed in WPC number 16560 of 2021 is under challenge. In the present intra-court appeal filed by the state of Odisha. So stop. The writ petition was presented on the writ petition was filed on when?
The writ petition was filed on 18/4/21.
Was filed on 4/5/2021.
18th April 2021.
4/5/2021. 4/5/2021. And was taken up for the first time on 6/7/2021. Stop. The petitioner had sought for a direction in the direction in the writ petition to regularize his post, regularize his service as tax collector, taking into account his continuous service. So stop. A learned single judge of this court disposed of the writ petition on the very first day when the writ petition was taken up with a direction to regularize the service of the petitioner and grant all consequential benefits as due and admissible to him in accordance with law within a period of 3 months. So stop. Next, in our considered view, Homa, as learned counsel appearing on behalf of the appellant, has submitted that the state was not given an opportunity When counsel appearing on behalf of the appellant has opportunity to controvert the averments made in the writ petition, and a writ petition which was allowed in the light of an order passed in WPC number 26860 of 2013 in respect of Angul municipality. Stop. Next. We are of the considered opinion that since the writ petition, since the relief sought for in the writ petition for regularizing the service of the petitioner was granted on the very first day when the writ petition was taken up by the impugned order, the said order cannot be sustained. The impugned order is accordingly set aside. The WPC number so stands restored to its original file. The state shall be at liberty to file counter affidavit within 8 weeks from today. Stop. Let WPC number so be listed before appropriate bench having the roster. Yes. Yes.
Item 32.
Please, Your Lordship. Your Lordship, item 32, I am appearing on behalf of the petitioner in the sub-item 1, Your Lordship. Your Lordship.
Who is in the other case? How many cases are there? 2 cases. 4 cases. Yes. Who is appearing for the petitioner? Yes.
For the petitioner, Your Lordship.
Is there one and Mr.
My lords, I am appearing for the opposite parties in both the cases, my lords. Opposite party number 6 in the first writ application and opposite party number 5 in the second writ application. There are 2 applications with identical prayer. My lords, I have filed the wakalatnama today in the registry.
So want to file affidavit?
My lords, the government has already filed the counter. They say that they accept the income tax certificate filed as HUF. So there is no dispute remains, my lords, to be adjudicated. Their only ground is, along with the tender, I had submitted a IT return as a bidder, Jitendra Kumar Agarwal. In bracket, it was written HUF. Now the government has filed the counter and they say that they will accept HUF.
When did you file the counter?
In sub-item 37977, their government has filed a counter. They have requested the higher authority of collector to take conference whether HUF.
So both of you are appearing for the same party.
No, when I am sub-item, they have tagged. I have not.
So he says he appears for the opposite party in both the matters.
I am for the opposite party.
Both the party, but petitioners are 2.
He's for the opposite party. You are the opposite party or petitioner?
I am the petitioner.
Okay.
Second case.
In sub-item 37977. They have tagged the matter here, my lord. Here the government has filed a counter. I have filed a tender also. And here that collector Tahsildar has filed the counter indicating therein that the opposite part number 5 he has approached with the individual capacity in Form F and giving the income tax return HUF. The sole intention of the legislature, my lord, it is on 27, it is written that you have to give a solvency or a bank guarantee which is valid for 18 months, and with a corrigendum, it has been that in ITR return also accepted. So sole intention is in that 27.7 that that amount is equivalent to the tender amount. Only because it has to be recovered. If any error is there, they can recover from the solvency and other thing. So motto of the legislature, if it is deferred, it's a 5-year lease matter. If somebody is a default, they only can recover through certificate proceeding. If the properties are in the name of HUF, they cannot. For which they have given concurrence to the higher authority, for they will accept it or not.
If I am permitted, my lords.
Yes.
Earlier, my lords, prior to 2021, it was solvency certificate or bank guarantee valid for 18 months. After the amendment in the OMMC rule, my lords, the solvency certificate has been given a go by, my lords. And in place of that, the IT return of the equivalent quoted amount or bank guarantee valid for 18 months is the rule now, my lords. And pursuant to that, I have filed the IT return, and the present petitioner, my lords, has not filed the IT return, and he is a disqualified bidder. Is a disqualified bidder, and the IT return, they objected that I have filed the IT return and in bracket is written HUF. I am the Karta of the HUF, my lords. And I have filed it as Jitendra Kumar Agarwal only, my lords. If there will be any default, the government will recover, my lords. He need not bother, my lords, how the government will recover when he is disqualified.
Yeah.
The government has already filed a counter.
Counter we have filed on 11/12/2023. Para 16 is our contention, my lord. In the second item, my lord. Sub item 37977. Para 16.
First item, we are adopting that counter. First.
Not adopting. But I see that no counter has been filed yet. I have to seek instruction, my lord. First item, we have not filed any counter. But the
My
second
friend is
item,
submitting that they have admitted.
no, we have not admitted.
No, my friend who is appearing for the opposite part number 5. That
Lordship,
said that
can
the
you
counter has been filed and government has
No,
adopted.
we have not
accepted.
admitted. We have not admitted.
It is not a flat matter.
The council is not saying that the government this is saying that no further affidavit is required in view of the stand which has been taken by the state.
Because the government has filed counter. That is the sum.
Whether counter is required.
He already counter filed and that has been no
Whether
required to
counter
file.
affidavit is required.
So this is your
Can we decide this writ petition without counter affidavit?
fifth writ application.
Here, my lord,
Whether counter affidavit is required.
the matter of fact, Lordship will consider because whole intention is to.
Even without counter affidavit, we can decide your writ
Yes,
petition. But that will be against you.
because I cannot go first.
His case also counter affidavit is there. Madam's case it is not there.
All right.
I will seek instructions so far as the first case is concerned whether to adopt the counter which is in the second case available, the stand taken by the government, or file a separate.
So simple question.
If I may clarify, my lords.
Both writ application.
If I must, Your Lordship, because in the first sub item, Your Lordship, the petitioner is very much eligible. The petitioner has submitted every document that is required, and I'm challenging the selection of the opposite party number 6. Because if the opposite party number 6 bid is cancelled, then I will be the lowest bidder, Your Lordship. And the reason
Why both the applications have been tagged?
because we both are challenging the selection of the opposite party number, private opposite party, Your Lordship.
The same person, opposite party, 5 in one and 6 in the other.
Yes, Your Lordship.
Two places they have quoted. One in Bargad, another in that is why they are. In one place he has accepted, another place it has not been accepted. That is the case.
No, this is in relation to the same query, my lords, not different. The same query.
No, not different.
Jagdalpur sand query, my lords, same query.
No,
Find out whether in the other case affidavit is there. No, in the
Second case it is there. Mr. Das's case it is there.
all right, file your affidavit with us. Or you can also file affidavit, Mr. Mon.
My lords, I'll file, my lords. But my lords, this matter is pending since 2023. Even though I am selected, my lords, due to pendency, my lords, the government is not allowing me.
Mr.
So,
Manzi
nothing like-
appeared today.
My lord, the matter got listed after the first date today. My lord. I had mentioned it, my lord.
You could have filed the affidavit.
You mentioned it.
My lord, let them file counter.
He has mentioned.
Copy nominative what it petition.
A writ petition copy may be solved. Okay.
The writ petition copy should be served on you.
Because first item I am not aware of the.
No, sorry, you will not.
He will argue unless she engages you. He will argue.
No, and verify with the same query or
That
different.
you are
Not
friends, you can
much
share.
Simple.
As jointly requested on behalf of the parties, list this matter on 1 week.
Grateful.
2 weeks. Right?
2 weeks. Yes.
Okay.
2 weeks.
Counter, if any shall be filed in the meanwhile.
And in the meantime,
After
amendment
everything
is found that deputy director binds with the authority. In the meantime,
All right.
that should be taken care.
Yes.
Item number 33.
Grateful.
My please. Also, kindly have a glance over the last order number 7. Last week directed OP number 4, Principal Secretary SC and ST Department to respond with the exhaustive counter. With regard to the bona fide of the petitioners, whether they are ST and whether it's a Gamron that area. Order number 7, not 6.
Seven.
Order number 7. Number 6 last order.
Yes.
Your Lordship, 1 more week time will be given by.
2 weeks.
But
2 weeks further
as
time is
far
allowed
as
to.
the old instruction is concerned, Your Lordship, the department said that since this section 3 to scheduled tribes and other traditional forest dwellers recognition of Forest Rights Act 2006 has been followed by the forest officials in granting permission for construction of the road. Will be a certificate?
No, we wanted to know his bona fide also of the petitioner.
Your Lordship,
Whether he was originally residing or just there.
for 2 weeks time will be given.
As requested on behalf of the state and the opposite parties. 2 weeks further time is allowed to file a counter affidavit in the light of this court's order dated 29/10/2020.
Item number 34.
Last occasion, Your Lordship permitted me to participate in the hearing. In this case, I
34.
Item number 33.
33.
Just now, Your Lordship,
We remember.
SC/ST
Yes, yes.
will file the counter.
So let me
I filed
counter
intervention application. Last occasion, Your Lordship permitted me to participate in the hearing.
I will permit you.
But I will file some objection counter affidavit. I may be added as the opposite party.
No, you do that. We will hear you, then we will.
34.
Item 34. And the students of PG students of radiology department of different medical colleges and institutions. My lord has already heard this matter and taken cognizance of the fact regarding the shortage of faculty, my lord, in medical colleges.
So whether affidavit has been filed? Affidavit has been filed.
The government has filed the counter and DMT also filed the counter.
Then?
The National Medical Council has also issued strictures in this respect, my lord. There is shortage of faculties. My lord, my point is, despite of such admitted shortage of faculties, the DMT is initiating training programs, depriving the petitioners as well as the trainees from proper infrastructure and faculty management. As per the counter filed by the government, my lord, there are in radiology department, the faculties are 22 and the trainees are 114 men. And the training program has already started from 1st January 2024. Well, my humble submission is, and there is one faculty for every 4 students. 1:4, man.
So you want that the entire focus should be on the students who are
PG students. If all the full-time faculty, if the full-time faculty is busy with the,
you have enough adequate faculty to teach you.
as per the guideline, all the faculties in the radiology department or obstetric or gynecology will be.
You are studying in which college?
SCB Medical College or different medical college of government of Orissa.
Government colleges. So those institutions which do not have the infrastructure.
Yes, ma'am.
As per the MCI or whatever you call
Medical
it.
Council of India.
Medical Council is no more. Medical Council has
National Medical Commission.
Medical Commission. So all those courses should be closed because in many of the colleges,
yes,
there is no infrastructure. So therefore, should we direct the National Medical Council to recognize those qualifications, those teachings?
Our ultrasound machines are used in the training programs, madam. Then what will be our future? We are doing PG classes for 2 years, madam. If 6 months training program will be conducted and our faculties, our machines are utilized in that.
Your machine?
We are the students and the machines are engaged in our studies.
For the patients.
Yes. Students. PG students.
The shortage, they have said, I think DMET has filed a counter saying there is a shortage of faculty.
They also
that should be
admitted.
taken for
Yes.
Take up
recruitment.
Monday.
Mr. Manti is not there. Where is Mr. Manti? Not there.
Please,
In many occasions, he is not there.
I mean, I don't know.
Mr. Panda, you are there in this case?
No, I'm not.
Then you are there.
Item.
Okay, there.
Profit advocate is there.
Where? Commercial advocate is where?
How many members are there?
3 minutes.
Sorry, 4 members. So we can call them. Call colleagues.
Item 35.
But I seek 2 weeks more time to file the counter application.
Yes, you are waiting 2 weeks for the time allowed to file counter application.
Item 36.
36, my lord, I have filed a counter application.
Yes, they have filed a counter, your lordship. My grievance here what is, my lord, that
Can we take up your matter on Monday?
yes, but now I know, my lord, the time.
Tuesday.
Matter. 37.
That is some experience.
Here for copy number 4, we'll file our affidavits. We'll file our written objections in this matter. Lordship may grant 2 weeks.
My lord, I also need to.
A written objection
Within 2 weeks.
to what?
To the writ petition.
All right.
MCL, man. I have put in appearance, my lord. I also
38 file counter affidavit and a subbing copy. 38.
37.
I'm sorry.
37 will take up after 2 weeks then.
yes, my lord.
Jointly requested on behalf of the parties, this matter on 2 weeks. From London Council appearing on behalf of the opposite parties and be at liberty to file their counter affidavits in the meanwhile. Yes.
Item 38.
Lordship directed to file counter affidavit, else 10,000 cost. We have filed counter affidavit in the meantime and served copy.
When did you file? Within the
Yesterday.
right?
Yesterday.
Right. When do you want?
The first week of December.
As requested on behalf of the petitioner, list this matter on second week of December, so as to enable him to file rejoinder to the counter act.